Yeah.
My lord, I'm praying for inclusion in the list for application, my lord.
We cannot follow you. Yes,
I'm praying for inclusion in the list for application, my lord.
please. What is the group?
The group 2, my lord.
Yes.
May I permit to mention, my lord, may be granted to file an instant appeal, my lord, without
File
certified copy.
Without certified copy. When was the order passed by the Honorable Single Bench?
16th March.
And what is the urgency? Briefly.
Urgency, my lord, Honorable Single Bench dismissed my application.
Anyway, you need not read out from the order for the, very well, to file it.
My lord.
My
You
lord,
get
may I be
it.
permitted to mention one group
Mr.
6
Dotto is-
application, group 6.
Please wait. Mr. Dotto, he is the
item
senior
number-
person. He is senior to you, so please wait.
Oh. My lord,
Yes, please wait. Yes, Mr.
item number 73 of the today's list.
Yes.
Well, only I'm praying let it be listed on Monday as mentioned matter because I have challenged the appointment of the private respondent. I
Yes.
will not be praying any interim order.
Yes.
Only opposition and reply that should be required, my lord. But and the appointment should be abided by. That's why.
That is almost like an interim order.
This is
why?
not interim order because
That is
appointment
almost
has
like
been
an
made. Appointment is under challenge.
That's
So I
right.
cannot get an interim order at the right moment.
Correct.
Huh.
And why should the private respondent work under a threat of your interim order from the appellate court? He
Because-
will be doing his future service.
No,
Uh,
I tell you, Rossi, because my lord, since his appointment is under challenge, he
correct.
cannot claim any equity. That's it.
That's right. But we cannot, let us apply your mind to the issue. You give the slip, we will see.
No,
But-
my matter is running in the list.
If you only want affidavit, we are willing to accept that proposition.
Well,
But
let it be. Let it be.
Shall be subject to abide by the result. That of course is a matter
But you're
which
also
is
let it be listed as mentioned matter.
You give the slip, we will
Yes.
apply our mind.
Okay. On Monday it will be listed.
His lordship will apply his mind to whatever you have stated, and then you will come back and check. You ask your learned junior to come back and check with the court officer.
I could not go.
His lordship will check your slip. We will examine the validity of your prayer, and then you come back. I'll come back. If not to be mentioned, mention matter for that.
My.
To be mentioned is for fixing dates
Yes, yes.
procedure. If not to be mentioned, mention matter. Because a substantive order is required.
Right.
Yes, Mr. Yes, he was there before you, Mr. Ghosh. Yes.
My lord, may I be permitted to mention one group 6 application?
Yes, give it. Yes, Mr. Ghosh.
May I be permitted to mention, subject to Lordship's approval,
Yes,
item number 101.
yes,
This matter relates to approval of the organized teachers.
yes.
Now, this is governed by the judgment of the Honorable Supreme Court.
Correct.
Let it be appear any date as your Lordship's as mentioned matter.
I'm not in a past.
I don't have any fixed date as per your Lordship's convenience.
I think we had the occasion also to pass a judgment on organized teacher. Lordship had. So therefore, you please give the slip. We will check with our record and then we will put it.
This is 101. I'm giving the slip.
Yes, Mr.
Lordship,
Gali.
may I be permitted to mention on matter, my lord, for inclusion in the list. Urgencies,
Sleep
it's an appeal by the state. Urgencies, my lord, the contempt proceeding has been initiated. Rule is being issued to secure the compliance of the order, my lord, despite pendency of this appeal.
You give the slip, write
Lordship,
the
Lordship.
content proceeding and also add the or give the order of
Contempt is returnable on 8th May. So
Very well.
I'm giving that order also, Lordship.
Yes, please attach it, staple it, and then give
Yes,
it.
Lordship. Certainly.
Yes, Dakun.
Lord, may I mention one matter?
Yes,
My lord, it's item 123 of today's list.
yes,
It's regarding TET examination
Yes.
2014. On first week of April, Mr. Navagomadas has mentioned it, and your lordship had allowed it and asked to submit a certified copy of the same.
give it. Dekhen it. Give the mentioning slip also.
Yes, my lord, it's there.
Ache. Yes, you want to say something?
Item number
Dakun, item.
Lordship, in item number 1, I'm appearing for the respondent number 7, 8, and 9. Lordships, I am seeking for a short passover. Lordships, my senior is on his legs from courtroom number 36. 9 থেকে বিদ্যাসাগর কলেজের governing.
I have some objection, lad.
Who appears for the college?
I am appearing for Vidyasagar College.
For the college?
Yes.
Why are you holding back? Your governing body meeting is at 12:30. We are
No,
going to-
lad.
Lordships-
Yesterday at 11:30 night, lad, a voice message has been sent. Voice message through WhatsApp sent by the teacher in charge, who is the ex-officio secretary of the governing body, that they have preponed the meeting at 11.
Then we'll,
Lordships, I have
Madam.
no instructions regarding this, but
that's right. No, please come into the middle. We had no, the matter is to be heard finally on 25th. That is number one. Secondly, the issue is that we had passed an interim order that you should not be disturbed, he should not be disturbed.
Yes, ma'am.
It does not, the college has stepped in the dispute. It is going to hold a governing body excluding the appellant, who is a member of the governing body. That as Mr. Ahmed is submitting is against the interim order passed by this court. We are saying that he will participate in the governing body meeting without prejudice to the rights and contentions of the parties in this. That is very clear for us, because we have to respect the sanctity of our order. Initially, when Mr. Ahmed pointed it out to us, we thought that the matter could be proceeded at a final hearing. We have gone into the final hearing aspect. That is 25th matter is fixed. Now the college principal cannot dilly-dally and play around with the order of this court and say that we are going to hold a governing body meeting at 11 and he is the teacher, whatever representative he is. That is what we intend to do. Yes,
may I submit one?
yes,
Let's see.
yes. You have preponed the governor. Please take your rest, take your seat. We'll look. What is the interim order, Mr. Ahmed?
That interim order is at page 18, lad, of the. That is not the interim order.
Of the
Of the can application number 4.
sorry.
That first order was passed on, this is on page 13. Page 13 is the first order passed on 7th
And
October,
vote কোথায় গেল?
7th October 2021.
Lordship,
That's what
may I be allowed to refer to that document from his brief? I don't have the brief also.
You need not. We'll give you all the assistance. They have been served with copy of
No,
CAN.
they have been, but there is a change in the brief. I
That's
have
right.
been appointed last.
Now,
year.
if there's a change in the brief at the 12th hour before this court, find out from your learned friend what is CAN for.
Definitely.
Because you're going to
Much,
hold
much,
a
much-
meeting today at 11, which is the subject matter before.
Much.
Where is the page? What is the page, Mr. Ahmed? Of
Page
the order?
13 is the order of the CAN 4. The first interim order passed by this honorable court. And then it was clarified on the basis of my prayer at page millet, start at page millet 16 and the relevant page is 17. Page 13, millet, page 15 is the relevant part.
You are a member of the governing body.
Member of the governing.
Which aspect?
Teaching, in fact, as research representative, millet.
Yes. Have you received CAN 4? CAN
Lordship,
4?
I have not received any document. That
Yes,
is
this was-
this is now been served.
Yes. Please look at page 18,
Yes, Lordship, definitely.
the last paragraph.
The convenience compilation shall be exchanged in
You
advance
read it,
by.
you read it for your own understanding.
Okay.
The last paragraph from the word however.
Yes, this very well covers my client, also protects my client also, Miss Ray. No, sorry,
Ms. Ray,
Miss Ray's client.
the appellant.
You are.
For the appellant, for
that-
the.
Right. I am for the governing college bodies, respond number 7 to 9. So there has been no direction as such
Ashok,
on the.
Madam, you are the principal appellant. He is the principal respondent. The matter will be on merits 25th. In the meantime, the governing body meeting is to be held. He is being debarred by the principal for whatever reason. It cannot be in view of this order. The participation will be there without prejudice to the rights of contentions in this appeal.
25th April, the matter was.
Correct, it is
Yes,
fixed.
yes, that's
It's fixed.
how we will
Party
argue on
list.
merits. on
Please
that.
give your names.
Yes,
Party, we
yes.
want to assure you, madam, that the
Lordship,
matter
I
on
also-
merits, which is the charge, will be heard as it is. In the meantime, this additional responsibilities which you hold or he holds in college, those can be discharged without prejudice to the rights and concerns.
Lordship,
Party
one
slash
more
R.
indulgence. Lordship, if I'm undertaking to filing my wakalatnama, because it's not.
Please file your wakalat.
Yes, we will, I will, in due
The
course of day,
meeting
I'll
that
file.
was held previously, Milad, I was not participated.
We are not interested in previous subjects. Now, as this meeting is concerned, you point it out before this court, you are going to participate without prejudice to rights and contentions in this appeal. Don't expand your prayers beyond this, Mr. Ahmed.
Actually, the scope is.
I am not, Milad.
Party,
Only just Milad, last occasion, Lordship, since I was debarring, Milad, this Lordship has clarified in subsequent orders. Even
Party this slash are, sorry, please wait. Party this slash are represented in the order of their names as printed above in the cost title. Full stop. This court is informed by Mr. Ahmed, learned counsel appearing for the respondent number, appearing for the, who is the, you're the respondent number, what in the appeal?
the governing, the respond number 9 and 10, Milad.
You are
8, 9,
you are the respondent number who in this appeal?
I am the respondent number 1 in their appeal.
In their appeal. Appearing for the respondent number 1 in this appeal. Appearing for the respondent number 1 in this appeal. Appearing for the respondent number 1 in this appeal. And also in support of the cross objection, C capital, O capital, connected with the, also in support of the cross objection, which appears for analogous consideration along with this appeal. Submits that in spite of an interim direction of this court, dated the 23rd of August 2022, the college is barring the appellant from participating, barring the respondent number 1 / the applicant in Can 4 of 2022 from 2023 from participating in the governing body meeting. Please hear our order, Mr. Shanal, and then participating in the governing body meeting, which is to be held today at 11 a.m. Full stop, para. The order of the interim order at its operative part, dated 23rd of August 2022, within bracket Supra, reads as follows. Bole এটা set out করে দেবেন। আমি a yellow sticker দিয়ে দেবেন, italics, full stop. It is pointed out that the interim order still subsists. Full stop, para. Mr. Shanal, Kamalan counsel appears for the appellant in MAT blank of blank and draws the with Mrs. Ray, learned counsel, learned senior counsel with Mrs. Ray, learned counsel, and draws the attention of this court to the fact that the matter is being presently heard and is next fixed for consideration on the 25th of April 2023. Full stop, para. The college is represented, full stop, para. Having regard to the facts brought on record and the stand of the parties, and particularly in the light of the interim direction passed by this court on the 23rd of August 2022, within bracket Supra, bracket close, the applicant in Can 4 of 2023 / the respondent number 1 in the appeal, being Matt blank or blank, shall be entitled to participate in the governing body meeting, which is scheduled to be held today, and governing body meetings scheduled to be held thereafter without prejudice to the rights and contentions of the parties in the present appeal. Full stop. Para. With the above direction, Can 4 of 2023 stands disposed of. Full stop, para. Let the matter return for consideration. Let MAT blank of blank and COT blank of blank with their other connected applications return for final hearing on the 25th of April,
Lordship,
2020.
I seek one
Only
kind
one-
indulgence. If it may be recorded that I have I have got the change of brief here.
Give your name.
I have given my name,
So and so appears for the college and undertakes to file the wakalatnama in
Vakalatnama, and the
the course of.
And only one clarification. It was mentioned at 11. But it was preponed by a voice message in the right platform.
No further. You attend to the meeting today.
Well,
Parties to
now
act
it's
on-
11,
Parties to act on a gist of the communication of this order.
My learned friend will communicate it. You communicate.
but it
with
is
the
already 11.
communicated.
We cannot take care of every contingency.
Lordship,
Mr.
I will,
Ahmed.
I will,
Please understand that.
I will
Because
communicate.
we are saying, we are giving you permission
I will
to
communicate
act
with
on
the
a
college.
gist of the communication of this order. You do not have to worry for the server copy.
Lordship, I will communicate on
Please.
because it's my.
Just
Only one thing, my lord,
Don't
I have-
mention, then what can, don't mention the date, time, because in terms of the notice, it is 12:30.
Very well, which is scheduled to be held today. should
Today,
be.
the
only
time
one reservation, your lordship, my lord, I have,
Yes,
because I am not a, my lord, member of the governing body.
correct.
My learned friend's client is a member of the governing body. I do not know, my lord, the agenda of the governing body's meetings today or tomorrow or day after tomorrow before your lordship's hearing. My lord, if there be any agenda pertaining to the issue.
They
being
cannot,
most
they cannot
certainly I
touch.
shall not.
You have to bring this to the notice of this court, that will be struck down. And they cannot touch this because
I
the
think
governing body meeting, that is not the issue before us.
No question.
This cannot be an agenda before them in their good sense. If he brings up this agenda or anybody, just bring it to our notice, we shall set it aside.
I believe it is also covered by Lordship's order that it is subject to the.
We are only, Mr. Shanal, giving sanctity to our interim direction.
Certainly, sir.
And I think without.
But I am
prejudice-
not also
Yes.
in his appearance.
And if the applicant brings up this, what is before this
Most
court.
certainly
it
not.
as a-
I can assure us.
No, it is at his own peril.
Then the court will
Yes,
always have-
thank
we
you.
will have to-
Much of.
Much obliged, Lordship.
Please ask your learned junior to give your names and we will. Ask your learned junior to give your appearances
Yes,
and then we
Lordship.
shall.
Yes, definitely, much obliged.
Yes.
Before I beg to appear on behalf of the appellant, my lord, my learned friend, my lord, regarding item number 4, my lord. My lord, regarding item number 4, my lord, Mr. Amitabh Choudhury is appearing for the respondent number 4 and 5, my lord. My lord, due to sad demise of his mother, my lord, he is not able to come to court, my lord. Humbly prayed, my lord, kindly fixed any date after 8th, my lord. May. Only, my lord, they are in favor of fixing a date after 8th, my lord. Any day, my lord. A date may kindly be fixed, my lord. Some precedents may kindly be given, my lord. Matter is required to be heard, my lord. My lord, this is a matter relating to co-warranto of, my lord, certain government official occupied certain posts, my lord, without having requisite qualification. My lord, while disposing of this matter, my lord, and dismissing our contention, because one of them, my lord, retired meanwhile and all this thing, my lord, the Honorable Court was kind enough to make certain, my lord, the remark, my lord, I am a victim of a disciplinary proceedings where my disciplinary authority, my lord, after tendering resignation, after 7 days, my lord, Mr. or may be permitted to put Mr. Ranjit Chatterjee's name, my lord. He is in the court number 14, my lord.
He is,
I am with him, my lord, in this matter. In read code, I have argued.
he is with you.
Lords.
My lord, I am appearing for the statement.
Parties slash are represented in the order of their names as printed above in the cost title. Mr. Para, on behalf of the private respondent, Mr. Onam Namta, learned advocate appears and seeks. What has happened to Mr. Chaudhary?
Mr. Chaudhary's
What-
mother passed away, my lord, sad demise.
When?
At 18th, my lord, in the evening.
My lord, they are in favor of, my lord, 8th onwards, any date, my lord.
8th onward, my
Only, my lord,
Any-
top of the list, my lord. This is my humble prayer.
And seeks an accommodation on the personal ground of his senior counsel, Mr. Chaudhary, full stop para, Mr. Amitabh Chaudhary, full stop para. The appellant is represented by Mr. Ronoji Chakraborty, Learned Counsel led by Mr. Ronoji Chatterjee, Learned Counsel, full stop para. The state is represented by Mr. De, Learned Advocate, led by Mr. Has Mr. Shopan Kumar Dotto come to court?
Yes, my lord. Yes.
And
He is already coming.
Give his name. Led
Yes,
by
my lord.
Mr. Shopan Kumar Dotto, Learned Additional Government Pleader, full stop para. The accommodation of the learned senior counsel for the private respondent stands granted, full stop para. Let the matter appear next under the same heading mention matters by date on the 10th of April, on the 10th of May, 2023. Full stop para.
If possible, within 5 matters, if possible.
It is appearing by date. May, 10th of May, 2023 at by date as a mention matter.
Keep your.
I'm great.
Dako bole diচ্ছে।
I am appearing on behalf of the appellant pursuant to your lordship's order on 16 March
Please,
2023. I was
Mr. Shaha, we have told ki Ashini. Mr. Shaha, come back after recess because this file has not come back at 12:30 because this file has not reached us from the department. So let the file come. If you give us a time which is convenient to all learned counsel, tell us. 12:30.
12:30.
12:30. Please come back at 12:30. We'll call it at 12:30. In the meantime, we're asking for the file to be produced before us. You may meet the file in the corridor.
Milord, in 6, Milord, yesterday, Milord was pleased to fix it next Wednesday because of there was some personal appearances and because of the difficulty, Milord has been pleased to fix it.
1 minute. 1 minute. Please
Mil-
take your seat. 1 minute.
Mil-
Vimal, এখানে এসো তো।
Milord was pleased to direct the petitioner to appear before Milord. The matter appeared yesterday in the list. Milord, as the petitioner has
There is no petitioner here. There is the appellant here.
Milord, the appellant. I apologize, Milord. The appellant. So, Milord, the appellant could not make himself present. So, Milord was pleased to ask to fix it next Wednesday, as I could heart my.
Ashok.
So, Milord, if your lordship kindly,
None appears for the appellant when the matter is
Milord,
called.
I am for the respondent, Milord.
We understand that. Mr. Dotto.
Milord.
None appears for the appellant when the matter is called. Full stop. No accommodation is paid for either. Full stop. Mr. Dotto, learned counsel represents the respondents. Eastern Railways.
Milord, Eastern Road.
Eastern Railway.
respondent / Eastern Railways, Para, in the above view of the matter, in the above view of facts, let this matter appear next in the combined monthly list of June 2023 under the heading. It is a Group 6 application.
My lord, against the writ, dismissal of the writ, my lord, the appeal, my lord,
Of course,
Group 6.
against the dismissal of a writ. Group 6 or Group 2?
My lord, Group 6.
That's right. That's the end of the
My lord, Group 6.
under the heading application within bracket. Obviously, if it is not against a dismissal of the writ, we will not be conversing with each other here.
My lord, my lord. My lord.
Group 6 application. Yes.
Yesterday, at the time of writing, I
Yes.
mentioned this matter for this week adjournment because
Very well.
the father of the petition appellant.
Very well. Very well. Very well. Very well. Mr. So-and-so, order to get it. Please take your seat, draw your breath, give your name. Mr. Devashish Kundu.
Devashish Kundu.
Mr. Devashish Kundu, Kamalan advocate, appears for the appellant and seeks an accommodation on the personal ground of and seeks an appellant on his personal ground. Yes, respondent / railways are represented by. You're seeking an accommodation on your personal ground.
No, my lord, the father of the appellant has admitted in hospital. That's why he unable to come before your lordship, as because last occasion your lordship asked to come present before your lordship.
On the personal ground. There's no formal order we may have expressed on the personal ground of his client. Full stop para. Mr. Kundu submits that due to the illness of the father of the appellant, he could not, he could not contact with his learned advocate, or he could not contact, personal grounds, seeks accommodation. The respondent / Eastern Railways are represented by Mr. Dr. Accordingly, when do you want the matter to appear? Mr. Kundu? Accordingly, let the matter appear next under the same heading mentioned matters next week.
Deep level.
Next week.
Start Kuri.
Sir.
Seven.
Lordship, I'm appealing for the board led by Mr. Gupta.
7. Matters pertains to selection process. The post of assistant teacher in primary school, the selection was of 2016. The only question involved in this appeal. Whether the candidates having qualification of special BEd will be treated as trained candidate, whether they are better qualified than those who are untrained and have been given appointment. These are the only question involved in this appeal.
Who is the primary respondent?
The board.
Lordship, the board, Lordship.
Which board?
Primary board.
West Bengal Board of Primary Education, Lordship.
Ask your learned junior to inform Mr. Ratul Biswas.
Lordship, I'm there.
Mr.
I'm led by Mr. Gupta, Lordship. He is coming, Lordship.
Mr. Kaushik Chaudhary.
Lordship.
Last occasion, place the impugned order. 1 second, if you to refresh your Lordship's memory,
Yes, let us see the order of the Honorable Single Bench and then we'll come back to you.
It starts from 402 and the relevant page is
Mr. Ahmed, what is the interim order you expect now?
No, this is on final hearing, and we will have started hearing, and it will take half an hour to complete the hearing. It's very short point is involved, whether the candidates having qualification of special BEd.
We will give you a date. We'll fix the matter at 2 p.m. We will not detain other mentioned matters for this. We'll give you a date at 2 p.m. We'll hear you out.
Let that be led. Only thing is I'm led by Mr. Bhattacharya.
Correct. Give us a convenient date for you. This is a matter to be considered. Mentioned matters are matters for which an urgency.
I follow.
There are other mentioned matters in the queue which deserve to
follow.
be heard. If your matter is a hearing matter, no problem with that. We will give you a date at 2 p.m. and then we can consider this matter with some bit of time and
Kindly, Milord.
and space at all involved. Mr. Gupta, this is a matter which does not require an interim order at this.
No.
It requires to be heard.
Lord.
So we are giving a proposal to Mr. Ask the gentleman behind not to be so excited. Please take your seat behind. Ask him behind to take his seat. His excitement should not disturb. Please take your seat or move. He is overexcited about the court's matter. He is to reserve the excitement outside court and try to convey his excitement to learned advocates who are entitled to take care of themselves. Mr. Gupta, this is a matter where interim orders are not necessary. It has to be heard.
Yes.
We normally keep mention matters for matters where urgency is staring at the face. So we'll hear it. We'll give you a date fixed at 2 p.m. as we have done in some other matters. So give us a convenient
Well, any day in the first week of May, Milord.
Your availability of your learned senior. See that and give us a date. Bimoleshwar, right?
Raspata Kolkata nahi.
May month, 2 p.m. में जो है ना. Please share, Mr. Bhattacharya, what this is a matter which is a mentioned matter. Not urgency is not there in the sense that it has to be heard out. We are giving you a date, Mr. Bhattacharya, at 2 p.m. on any date, so that we can hear you out with sufficient time and space at our
Yes,
disposal.
that's very convenient for me. Lashikali, fix any date subject to court's convenience on first week of May.
First week of May, let us see what date is available. We are told we have fixed several matters at 2 p.m. on first week of May. We can give you an independent free date on the 15th of May at 2 p.m.
Very good.
Your diary is more important than our diary, perhaps.
My diary is absolutely opposite. 15th of May, very well. 15th of May. সোমবার, হ্যাঁ ঠিক আছে। অন্য কোনো program ফেলো না।
2 p.m. 15th.
At 2 p.m. Ashok.
He has to manage 2 fora.
No, you have to keep, Mr. Bhattacharya, you have to keep a second man with you who will control your diary when you go to every court. The first man will be attending to your books, briefs, citations. This is your second man will be ready with your diary. Otherwise, it will be difficult for you to coordinate.
Very much necessary. I am creating trouble for myself. Looking the program, they did the could
Party slash are represented in the order of their name slash names is printed above it. Full stop. Para, the matter matter appears under the heading mentioned matters today. Full stop. Para. Paper books are ready.
Always
Paper books are ready.
Special gate
Parties are addendum.
Ordinary
That addendum. That at this stage there is no scope for considering any prayer for interim order, and the matter requires to be finally heard. Full stop. Para. Accordingly, comma, let the matter appear next for hearing fixed at 2 p.m. on the 15th of May.
That's a Monday.
At 2 p.m.
2 p.m.
Yeah, every.
করে দিন তুমি কোথায় থাকো তুমি তোমার
Just 5 minutes in only হবে। ডাকুক।
My lord, I am for a very short passover. Learned advocate of the respondent is on his legs in court number 9, my lord.
I am for the appellant, my lord.
Very short passover, my lord. I am seeking for a very short.
Very short means how short? It is 11:30 now. Give us a time because learned advocate has other business to attend to.
My lord, if your lordship kindly fixes at 12.
12.
12.
So because learned advocates cannot be held back in one court. They have to move and do their work in other
Let it
courts.
be, my lord,
So
by
the-
tomorrow, your lordship, please, my lord.
No, tomorrow would be another
Thank
day.
you, lord.
So
Right,
12 o'clock
12,
today,
12,
come
12.
back.
Yes, yes.
That's a very short
Matter, my
pass.
lord, be on next week, my lord. I am for the respondent number 5, my lord. My service provider has been terminated.
Let him come
Fine.
at 12 p.m.
My
As your
lord.
lordship.
Much obliged.
Yes,
For the appellant.
yes,
Lord,
Mr.
I am for
Ghosh.
the respondent number 6 university.
Lord, pursuant to your lordship's direction,
And
I
for the
prepared
respondent number 5.
I prepared a supplementary affidavit. Okay, it is annexing the rules. এটা দুদিন একটু short.
Let us have a look at the order under appeal.
My lord. Sir, may I give you also the short issue involved in this instant appeal?
Let
Whether
us,
the
let us read the order. We'll come back to you.
long order.
Yes, we'll have the, please take your seat, Mr. Ghosh.
My lord.
Let us go through the order impugned and then of course you'll make your
My lord.
service.
Times 760 times 760.
The first point is the leave rules of 2013, they were applied to you.
Whether it is applied to me or not.
It was. That is what the single bench holds.
Yes, yes.
However, you are not given 300 days benefit, you are given 276 days. Now, if that is a calculation by the, how does the court get into that factual aspect?
What happened, I have been given leave encashment benefit for 276 days in terms of the earlier rules. Now, subsequently rules has been amended after my retirement. But the amendment has been given is a retrospective effect from 2009. The Honorable Single Judge pleased to hold that since the amendment came into effect after retirement of from my service, I am not entitled for 300 days. But the notification says the amendment given effect as a retrospective effect from 2009. If that be given from retrospectively, I am entitled for that 300 days. And that's why your Lordship was pleased to direct me to affirm a supplementary affidavit annexing the rules. I've annexed the rules.
That takes care of the amendment and the legal application of it. Now, on the factual part, even if 300 days was applied to you, what the single bench holds that you got 276 days, not 300 days.
But in that score, my lord, the college authority, after calculation,
sorry to interrupt you, that calculation of days is irrespective of any amendment.
Yes,
any amendment,
yes.
Post, present, future,
Yes.
the days cannot vary.
My lord.
The allotment of days to you. So the 276 days, how do we get into that aspect?
No, but what happened in this matter, college authority after calculating, send the file to the concerned department for 300 day leave encashment benefits. The concerned department, without going into the anything, without going into the calculation, simply says you give 276 days. For that reason, college authority has compelled to give 276 days. That is the main issue regarding the calculation. My leave encashment was never calculated. Originally calculated by the college authority, it was sent to the department. Department says he
Show us the
may I show you the application.
show us the director's order.
Well, that is page. Application. My lord, I'm just. My lord, kindly excuse me, my lord.
The order where it was calculated, the director's order by which you challenge in the
Yes, my lord.
writ petition.
That is
Which
page.
page?
My lord, I'm extremely sorry. কোথায় গেল আমার কাপ দেওয়া ফাইলটা ব্রিফটা কই?
Mr. Ghosh, normally you're so well prepared.
No, my lord, my brief has been missed.
46.
Then we would like to
46.
I'm extremely sorry.
Page 46.
my lord.
page
46 of the application.
of the application.
Madam, I'm extremely sorry, my lord. My brief is. No, আমার দাগ দেওয়া briefটা আনেন।
Yes, reasoned order 20th of April
Yes, my lord.
2015.
That was impugned before the honorable single judge.
That's right.
Page 48. Yes, page 48, item number 4.
Oh, my lord.
That is the only point in the to be decided in the appeal.
My lord. And regarding the lawsuit, also regarding the interest part.
That is
But
in the event. So now it is for the college to answer. Who represents the college?
Before my learned friend says, may I show just two documents to your lordship?
Please, please.
If your lordship kindly come to page 67 of my application.
Page
67, 67.
Yes, Mr.
But
Ghosh.
kindly see, this has been wrote by the Director of Public Instructions to the teacher in charge. It starts with subject report regarding the complaint of Dr. Vishwanath Des, former principal, Siddha CS College. With reference to the subject cited above, you are directed to furnish a report to take immediate action as detailed below. Papers for pension in favor of Sri Vishwanath Des, ex-principal of Silda CS College, are yet to be received by the office from the college authority. The college authority is being directed to submit the same immediately. The claim for leave encashment of the petitioner has been submitted to the office with a claim for encashment for 300 days. Existing rules permit to allow this for 240 days only. The college authority is being directed to submit the paper after due rectification without delay. Now, the Director of Public Instruction himself directed the college to give 240 days.
You have exceeded that. You have gone into 276 days.
76.
Now the question is that 240 days, therefore you have crossed that.
My lord.
That doesn't apply
after
to you.
calculating found it is 300 days.
That's right. Now you're only short of 24 days.
My lord.
College will explain why did they give it.
My lord.
That is the meat of the matter, nothing more. Yes, college. Why 276 days? Why not 300?
My lord, that is, my lord, not record, my lord, but this was corrected, my lord, at the office of the DPI.
Office of the
DPI.
We cannot.
Office of the, my lord, Director of Public Instruction.
What is the basis of the correction?
My lord, we send it, my lord, 300 days for several times, my lord.
Where did you send it? Where is the document?
My lord, document, my lord, page 67, from 67 itself appears that we send it for 300 days.
Correct.
My lord, in his account, my lord, more than 300 days is available.
Correct.
My lord, for that reason, that is, my lord, the maximum days is 300 days. For that reason, my lord, send it to the DPI for 300 days. My lord, DPI asks us to give, we can give only 240 days, not more than that. After that, we show the, my lord, the relevant rules, my lord, and the other notifications that he is entitled to 300 days.
Yes.
After that, also, my lord, on verbal instruction, my lord, we are compelled to give 276 days.
276 days. How can you come? Either you give 300 days or you give
Or
240
but
days.
after
How do you come to a figure of 276?
I have seen the calculation, my lord, and talk to the, my lord, the college authority. College authority, my lord, the college authority said whatever done, my lord, this is done on the verbal instruction by the DPI. Well, in his account, more than 300 days is available.
Yes.
This is the situation.
And there is no dispute that the amendment applies to him. He is covered by the amendment.
300 days amendment apply to him.
Applies to him. So on all aspects, he is covered. And yes, who pays for the DPI? What is the basis for coming to?
On the basis of the calculation made by the college authorities, we took the decision.
Where it shows the page. College is saying we
48,
never gave you.
Item 4, page 48, item 4.
No, give us a document. Which is the document?
They has also claimed for leave encashment of 24 days. It appears from record that the college authority has submitted for 276 days.
Where is that document?
The college authority has submitted for 276 days of leave encashment of Sridhar Bhaitya, letter number such and such. Dated such and dated undated to 2020.
Where is that letter? Yes.
However, signatures appears to be on 16th August 2013. This directorate has calculated the leave encashment of 276 on the basis of the aforementioned submission of the college authority.
Followed. Now, where is that letter? Because college is saying they want.
The college should produce the reference of
Page
letter.
78 of the application.
Page
78, 78.
College should produce, but at this stage, college cannot shirk his responsibility.
But here 300 days has been given. The same memo number.
Yes.
Can you see the memo number? Mark the memo number. Reference SCCF 73 of 2013. Number in impugned order, page 48. Reference number SCCF 73 2013.
300 days.
Application থেকে
হ্যাঁ,
পেয়েছো না, কত টাকা?
We are 300 days. And we are surprised 276 days dropped from the thin air. Or was the heat taking its toll on the person? Not there, no mention of 276 days. It
Yes.
could be 240, it could be 300. 276 days is
All the-
whose innovation?
Language of this letter, your order, your lordship kindly sees. Hide letter number such and such, dated such and such, however, signature appears to be on 16th August 2013. This director has calculated the leave in
This is a
276 days on the basis of the aforementioned submission of the college authority.
This, Mr. Mitro, this is not a huge issue. Correct the error. We are giving you opportunity to do so.
Lord,
Call the
Mr.
college,
Lordship,
call the person. And this 24 days, we need not we need not occupy our
first of
precious
all-
time with this.
First of all, my lord, we would find out the letter written by the college authority.
This is the page 78.
Yes.
It has
but we
been
have to
found out.
verify-
The memo number matches.
Lord, we have to verify it from our.
Verify it, sit down with them, not,
Your lordship kindly gives me 7 days time, we would come next.
yes,
week.
and then come back to the court with a proper answer.
Lordship.
It's only 24 days leave in cash. That's it.
Lord, I am disputing the statement made by my learned friend appearing on behalf of the college authorities, my lord. Since, my lord, it is crystal clear, my lord, from item number 4, page 48.
No, you stand with that, but the documents show otherwise. So you have to revisit the issue. Call the college, call the appellant.
My lord, let us find out this document, letter written by the college authorities.
Yes,
From our file,
we are giving you time.
lordship. my
You
lord.
match
From
your
our file,
file.
from our file, my lord, we.
Match your file with this record and give the court an answer on the
Lordship,
next
my
day.
lord, lordship.
Yeah. Yes,
As your lordship.
that is all. Yes, Ashun.
Revisit করে কি আগে দেখে নি কি আছে পরে revisit
Please
হবে
take your
তাহলে।
seats.
তারপরে তখন
Party
কোন
party
file?
list slash are represented in the order of their names as printed above the first title. Full stop. The issue in this appeal is the denial of the claim of the আপনি সামনে এসেছেন বাসুদেব বাবু আপনি শুনতে পাবেন কোথায় বাবু বাবু একটু শুনতে অসুবিধা হবে আমার একটু ইন্টারাপশন হলে তখন আমার ফ্লোটা আটকে যায় ঠিক আছে আমার বাড়াতে ওই মানে এখান থেকে আমরা কি is the issue in the appeal is the denial of the claim of the appellants as the writ petitioner for leave encashment of 300 days following his retirement from service as principal of the respondent slash college edition. Para. By the impugn order of the Honorable Single Bench dated the 9th of January 2023. In the writ petition being WPA 17936 of 2015, comma, the Honorable Single Bench came to the finding that although the writ petitioner was entitled to the benefit of a maximum of 300 days leave encashment, comma, in terms of the calculation by the Director of Public Instruction within bracket DPI, comma, West Bengal, the writ petitioner was entitled to in cash 276 days leave. Full stop. It was further recorded by the Honorable Single Bench that there is nothing in the pleading to suggest that the said calculation within bracket of 276 days, bracket close, was erroneously done by the DPI. Full stop. Para. Mr. Ghosh, the stand of the appellant slash the supplement of the stand of the appellant slash the writ petitioner is supported by learned counsel appearing for the college authority by pointing out that at all times the colleges, but at all times the college had sent a calculation of 300 days leave encashment in favor of the writ petitioner to the DPI full stop, by way of proof, by way of proof of the aforesaid submission. The college relies upon a memo number SCC F-73/2013 at a page 78 a page dated blank from the principal slash teacher, from the teacher in charge of the college, and countersigned by other authorities of the college. First, it is pointed out that the said memo clearly mentions payment for leave encashment against payment for leave encashment for 300 days. Full stop. Mr. Mitru Kamalan Council, appearing for the state respondents, appearing for the DPI, however, draws the attention of this court to the reason order of the DPI dated the 20th of April 2015 at clause 4 at clause 4 thereof, at paragraph 4 thereof. By the said reason order, it is paragraph 4 thereof. At paragraph 4, it is inter alia stated that the appellant slash the writ petitioner has prayed for leave encashment for 24 days, which is 300 days less 276 days of leave encashment, less 276 days of leave encashment already granted to him. Full stop. It is further pointed out that the DPI, that the Directorate of Public Instruction, that the Education Directorate, that the Education Directorate, E capital, D capital, has calculated the leave encashment of 276 days on the basis of the submission made by the college in terms of his memo number, which is again memo SCC/F-73/2013, undated. From the having regard to the submissions from the collective submissions of the parties, from this court is of the view at this stage that the conclusion of the DPI as appearing at paragraph 4 of his reasoned order R capital O capital dated 20th of April 2015 stands flawed FLAWET since from the memo number blank, which same memo number SCC F13 thing, which appearing at page 78 of the stay application connected to this appeal being stay application for appropriate order being can 1 of 2023 connected to this appeal. It transpires that the college authority had sanctioned a leave encashment of 300 days in favor of the appellant. Full stop para in favor of the appellant / the writ petition. Full stop para in the light of the above discussion, the DPI, West Bengal is directed to revisit the issue of grant of the deficit leave encashment of 24 days as claimed by the appellant / the writ petitioner. First, the DPI shall consult the DPI shall be entitled to consult the college authority and the appellant while revisiting the issue and pass his reasoned order. Full stop. And passes reasoned order. Full stop. Let such reasoned order be communicated to let such reasoned order be communicated to the parties and also be placed before this court on the next date by way of a report on affidavit through learned state counsel. Mr. Para, let the matter appear next. Yes, sir. It is. Let the matter appear next. Let the matter appear next under the same heading mentioned matters on the Ormachuti Ported in the monthly combined list of June 2023. Now, it mentioned matters on the full stop. Before parting with this discussion, it is made clear that the appellant is covered by the memorandum dated 20th of December 2013. Since the same memorandum dated 20th of the thing, amending GO number 762 dated 3rd December 2009 with retrospective effect from 3rd December 2009 with retrospective effect from 3rd December 2009 in connection with a grant of leave salaries, in connection with enhancement of leave salary encashment in favor of retirees. In favor of retirees. Yes. Next date at the remote. The mentioned matter. গরমের ছুটির আগে
নাম দিয়ে দিয়েছো?
Seven 762 dated 3rd December. পাঁচেরটা সুপ্রতিম না পাঁচেরটা 11th May. Mention matters 11th by date. Yes. Matter goes back to the DPI. We have referred to the stand of the college. They have said that by the said memo, they have mentioned 300 days. You have quoted the memo in your reasoned order, but you have said 300 days has not been quoted, and therefore you came to a finding of 276 days. Ex facie, we find that your conclusion is not correct. We have asked you to revisit the matter in consultation with the college and the appellant, only on the point of the deficit 24 days leave encashment. Come back with a reasoned order and place it before this court, communicate it to the parties, place it before this court on the next date. We meet on the 11th of May, 2023, under the heading mentioned matters by date,
Much of it.
so that we can finish this issue.
Yes.
We have additionally stated that the amendment to the rules of 2009, which is the leave encashment rules, applies to the appellant, since there is no dispute that the amendment takes place with retrospective effect.
In fact, the university amendment took place in 2013, but the original leave rules, which is published from the state government, that is of 2009. But our leave rules were amended in 2013, the university leave rules, upon which the leave is calculated.
That is after his retirement.
Pardon, my lord?
That is after his retirement.
Yes,
After his
my
retirement, that
but
is the finding of the learned trial court.
But still then you have not, you have calculated it at 300 days.
My lord,
The college has done so.
college has done so.
You have
Yes,
not
college
raised
has
an
done so.
objection.
No, I have nothing to say except to produce my leave rules, which was directed by the learned trial court also. And that is why the findings was the petitioner retired from service on 31st of March. But the university's leave rules and assent of the governor, the chancellor, was done in April 2013. So that is after his retirement. That is why these leave rules giving amendment of 300 days was not applicable to him. This is, in short, the findings of the learned court below.
So what is your stand now?
My lord, my stand is that the leave rules of the Vidyasagar University is applicable, which took place in April 2013 after his retirement. That is our stand.
The date of the assent of the government.
But the,
Yes,
but the
because we
that-
cannot
that
go
rules-
beyond the assent of
that
the
rules
governor, the
give
chancellor.
effect retrospectively.
My lord, he has given the supplementary affidavit annexing our leave rules.
Sure.
Now, please kindly have a look to the
Why did you remain quiet for so long then?
supplementary.
Vicky?
My lord, in the supplementary affidavit, now, please kindly come to page 5. Assent of the Honorable Chancellor was dated 26th April 2013. Page 5 of the supplementary affidavit is filed today, which was done pursuant to my lord's order. This is from the Secretary to the Government of West Bengal Communication. It is filed today. The amendment of leave rules for teachers of government aided, including erstwhile sponsored colleges in the state under Vidyasagar University. My lord, the proposal for amendment of leave rules for the whole-time teachers and principals of affiliated colleges, erstwhile sponsored colleges of the Vidyasagar University, my lord, under part 2, under chapter 19 of the Vidyasagar University first statutes with up-to-date amendments in tune with the provisions of this department GO number 762 dated 3rd December 2009 and number 163 dated 17 February 2011 was under active consideration of this department for some time past. After careful consideration of the matter, the Honorable Chancellor has been pleased to accord approval in terms of section 51(5) of the Vidyasagar University Act 1983 to the amendment of leave rules under part 2, chapter 9 in the Vidyasagar University first statutes. These ordered issues with the concurrence of the Honorable Chancellor with a memo dated 26th April 2013. So, my lord, this was done after his retirement.
The question is, you adopt a leave rule of the state government. And what do you say in this? You are in tune with the amendment.
In tune with the amendment.
That's right. So whatever you bring that into your statutes, you cannot have a different position apart from the whatever the parent incorporation which you are doing in the statute. There can be no two conceptions
My
of the
lord's
leave
findings
rules.
is
You
also
cannot
getting.
have two time periods. It is in tune with the parent amendment suggested.
Yes.
Only thing you are bringing it into your statute books on and from this.
My lord, on the last occasion which my lord was pleased to direct that the applicability of the leave rules of the Vidyasagar University, whether from the date of giving assent of the chancellor or from the date of the rule issued by the state government, will be hard
What
today.
is that? Why
So,
did
my
you
lord,
remain silent for that? What is your point on that?
in fact, I twice I stood up,
Oh, yes.
but I could not disturb my lord as my lord was asking them. So
Yes.
twice I stood up to say something.
What is your
But
point
my
on
lord,
that?
I could not because I could not.
What is your point on that, Mr. Sengupta?
My lord, my point is that University could not go beyond its own amendment. University amendment to, my lord can discard my my points, but this is my
Please
submission.
take your seat, Mr. Ghosh.
This is my submission that our Vidyasagar University first statutes and first acts all are, my lord, these.
No, the situation is, Mrs.
Yes, my
Now we are on your point.
Yes, my lord.
Situation is there has been an amendment by the parent department.
Parent department.
The governor, what does the governor do as the chancellor? The chancellor says, please incorporate that in your.
Well, so long our statute is not amended, we could not give effect to the original amendment given by the higher
Correct,
education
correct.
department.
So he retired before amendment of your statute.
Yes, my lord. Yes, my lord.
Now
Our-
you gave now the question is you gave a effect to your statute to that amendment from 1st April.
Not from 1st April, my lord, from 26th April 2013, when the assent of the chancellor was given, my lord, we could not go beyond it. My lord clarifies this, that this amendment, though it was incorporated after his retirement, even then it will give effect from, my lord.
Yes,
can give it
yes,
this.
the content of the amendment is retrospective operation of
But that is
retirees.
not written here. In our amendment, that is not written with retrospective effect. That part is not clear here. But
Correct.
my lords kindly give.
Correct. But even then, how does 276 days come up? In
Yes, well, that
in
is
that
also.
even 240 days
That
will only.
240 days or 300 days. But
Correct.
276 days is really, I am nothing to say on that. That is
That's
on
it.
their part.
That's
But
it.
so far our amendment is concerned, in my humble submission, that we cannot go beyond our amendment. We cannot go beyond that, so the parents department done in 2009, but I can place only this, our amendment took place with the concurrence of the Honorable Chancellor. Even the communication was made subsequently in the month of May, but on 26th April,
So
the
when did the college write the letter to the, that is on?
Page 78, my lord.
Stay application
Page 78.
is undated, but in 2013.
16th August 2013, signed on. In the bottom, my lord, left hand side.
Well, that is
Because
after the
difficult-
amendment was done.
Because the difficulty is he may not be the only case. You may be flooded with other cases of this sort. That is the effect if somebody is allowed.
If lordships kindly clarify it, I
But
think
may I-
everyone will be
My lord,
benefited.
may I?
That this will give effect from the date when the parents department passed the order, the higher education.
That
State should take instructions on that.
that is I annex the notification.
State should take
It
instructions
is
on
already
that.
given by the state government.
1 minute. We'll come to you. Yes, Mr. Ghosh, let us say this. This has changed the complexion of the issue because if you have adopted it from the 1st of April, then a pre-retiree, if does not benefit because he retires from the university. Therefore, he does not
Lordships-
benefit, although the amendment is retrospectively
yes.
applied.
Well, lordships kindly, while my lord is directing the DPI to revisit it,
Correct.
lordships kindly add this also to consider that when from this amendment will take place. If that is from the parent, then 300 days he will get it. Lordships
And
kindly
even the
also
DPI
add this portion.
Yes, yes. We think that would be sensible. This point has to be gone into. Because they have given 300 days after the amendment. College is under the university. It is after the amendment of the statutes. So how did they arrive at 300 days without?
Because they also stated that all universities are to amend their leave rules.
Correct.
Because so long the university amendment has not come into existence, the rules cannot be incorporated, but and giving any effect can be given to that. So our amendment
Followed.
took place on 7th of May,
Followed.
according to this. And the annexed pages are also the annexure 1I, the leave rules applicable for all teachers.
Followed.
There 300 days has been mentioned, but with the effective date. If
And after that, how come 276 days comes? So that is
76
also.
days is really of no substance.
Correct,
Either
correct.
240 days or 300
Correct,
days.
correct.
Because everyone has in their credit more than 300 days,
Correct.
while a long period is really done. So
Correct.
276 days really having no
Yes,
substance. That means they have
that's
followed 300 days.
correct.
But let it be, my lord, in clear, unambiguous terms, we passed by the DPI to revisit the issue.
Yes.
That is why I'm requesting my
Yes,
lord
yes,
to
yes.
incorporate these in the order also to clarify this position.
Yeah, we find your submissions to be quite correct. Yes, we shall do that possibly. Yes, Mr. Ghosh.
My lord, subject to what my learned senior pen says, just only to add two things. My learned senior pen shows the amendment of the leave rule of the university. My lord, kindly come to page 5. of the supplementary affidavit. I just read one paragraph of the letter. The proposal for amendment of leave rules for the whole-time teachers and principal of affiliated college, erstwhile sponsored college, and the Vidyasagar University under Part 2, under Chapter 9 of the Vidyasagar University First Statute 1983, in tune with the provision of this department geo number 3rd December 2009 and number 17th February 2011 was under active consideration of this department for some time past. Now, kindly look into the notification that is 3rd December 2009.
We have seen that.
That is annexed in my
Yes.
application.
We have seen that.
Now, kindly come to page 4, the just previous letter. Page 4. This is the notification issued by the Joint Secretary, Higher Education Department. It says the matter of allowing cash in equivalent to leave salary in respect of whole-time teachers and principals of government-aided college, including erstwhile sponsored colleges in West Bengal, had been settled in the leave rules framed by the department in para 15 of this department geo number 13 December 2009. And the university were asked to amend the statutes suitably. After carefully reconsideration of the matter, the governor has been pleased to say that para 13 and para 14 of the geo number 762 dated 3rd December 2009 stand deleted with immediate effect. It is further clarified that every whole-time teacher and principal of the government-aided colleges, including erstwhile sponsored colleges, shall be entitled to leave salary of the earned leave accumulated at his her credit after cessation of his service by way of retiring or on superannuation, voluntary retirement, or death in hardened, provided the maximum number of accumulated leave and maximum leave encashment shall be 300 days, subject to the university makes suitable amendment to their statute in the light of geo number 762, 3rd December 2009, and amended by the instant memorandum. Subject to the university amending their statute in this regard, these will take effect from 3rd December 2009, taking into account this department geo number 762 EDN, it is 3rd December 2009. Number university amended the rule on 7th May 2013, and this notification of 20th December 2013, giving a retrospective effect of the amendment taken by the university from 3rd December 2009. The last paragraph.
The university amended its statutes from 7th May
2013. But that amendment will give a retrospectively from 3rd December 2009. That is the last paragraph. Subject
and
to
this
the
memorandum, I mean, even later than that, 20th December 2030.
Yes. Subject to the university amending their statute in this regard, these will take effect from 3rd December 2009.
That is right. This is the parent memorandum, which are subject to university. This is the parent memorandum.
Yes, my lord.
How could the university carry out an amendment in 7th May 2000 when this was not born?
Not the parent.
No.
Tell us, explain to us.
No, this is not the parent. Parent is 762, 2009.
Correct. That was the unamended.
Unamended, my lord.
40 days.
Yes. No, that is 300 days.
That is 300 days.
300 days. After that, my lord, the university amended leave, my lord, on 7th May 2013.
Yes.
My lord, after that, my lord, the Higher Education Department again issued a notification amending 2009 notification and giving the retrospective effect from, my lord, 3rd December 2009.
So 240 days was where?
As per the rules of the university.
As far as university rules.
As per the university.
Not as far as.
No.
Very well. The DPI will revisit this issue and give us it. Ashwin.
In terms of this notification solves.
That is a correct. We need a feedback on that also. In the reasoned order, this has not been considered.
Yes, if my submission.
Yes. Ashwin. Mention matter. DPI will produce his report.
In fact, my lord, I stood up twice, but so long my lord is not asking me, I cannot
No, you must say, my lord, this is not the way you are proceeding. This is the way you should proceed. So you must actually change the direction in which we are proceeding. We were proceeding only on 300 and 240 days. So you should immediately, you should say that, no, this is one direction, but an important direction is this also.
Get.
Much obliged, not get.
Item number 8, my lord,
They have not called it. এটাকে DPI কে বলে দিতে হবে। হ্যাঁ?
In this matter, my lord, I am appealing for the appellant.
My lord, I beg to appear for respondent number 2, that is the central warehousing.
I am appearing on behalf of the respondent number 5, my lord.
My lord, in this case, my lord, the impugned order is, my lord, the refusal to the impugned order is, my lord, refusal us to join our duties as, my lord, the last annexures, my lord. My lord, refusal to, my lord, us to join our duties as security personnel in the, my lord, the security agencies, my lord, the appointed by the Central Warehousing Corporation. Under this scheme, my lord, DGR, well, if your lordships have a look, my lord, the refusal of interim order. At, my lord, page 50.
Page
At, my lord, running page 53, my lord, the
52.
53, my lord, that is the impugned order, but the last annexures. The interim order was, my lord, was rejected. Well, the case is this, my lord, before that, my lord. The case is this, my lord, there is a defense welfare, my lord, the wing of Government of India that is called, my lord, Director General of Resettlement, where the, my lord, the retired officers and the retired soldiers are, my lord, they are settled for further employment or the business and all. Officers, my lord, are liberty to, my lord, start a security agencies. Those agencies can be, my lord, appointed by the, my lord, the central enterprises. And by the soldiers, 100% soldiers, they can also be appointed through that agencies for the, my lord, security of that, my lord, enterprises. This is the main scheme of this. If you lordships kindly have a look to, my lord, the Article 14 of that, my lord, the guideline. It is, my lord, at page 14. Why am I before lordship? Page 14b. Article page 14b. That is, my lord, at page 16. 14b, my lord, says that age of the security guard, my lord.
First of all,
My lord.
Please identify yourself. Who are you? Why
My
did
lord,
you go to,
I am.
why did you go
yes,
to the
yes.
writ court? What was the prayer before your writ court? You have not said anything. You've just straight away gone into page 14. Who
We
are
are-
you?
we
What
are-
are you doing? Why did
Yes,
you go to
yes.
the writ court?
Yes.
What is the legal right infringement you allege? Give these basic particulars.
we-
You have not identified yourself.
I'm
We are
sorry.
hearing page 14, para 14, impugned order. What is the structure? Where do you
Well,
stand?
yes,
How
yes.
do you come to the appeal court?
Yes.
Tell us the brief background.
I'm sorry, my lord. My lord, we
Who are you?
I am the, my lord, the security personnel, my lord, appointed, my lord, as a security personnel at, my lord, the Central Housing Corporation through the, my lord, the security agencies. Those are sponsored by the, my lord, the DGR, Director General of Resettlement. The point is, my lord, in the DGR guideline, the upper limit of, my lord, the age is 65 years. And, my lord, all along, my lord, we are serving the, my lord, the company, Central Housing Corporation, through the, my lord, the different security agencies.
You are ex-serviceman.
I am ex-serviceman. And, my lord, they, my lord, all of a sudden, they disputed that our service was stopped, not terminated, at the age of 60.
Who are they?
Well, they, my lord, the principal employer of the Central Warehousing Corporation. My lord, now they are appearing for the respondent number 2.
Central
Warehousing Corporation.
Warehousing Corporation.
Warehousing Corporation. Now they appointed, my lord, the respondent number 4. My lord, the last was the Sundipan Security Agencies. And, my lord, our service as security personnel were continued throughout several, my lord, security agencies. Those were appointed for the findings. The last was the Sundipan Security Agencies. My Sundipan Security Agencies, my CWC, Central Housing Corporation, disputed the question that we cannot work after 60 years. My lord, if your lordships kindly have a look to, my lord. And that was, my lord, my lord,
What is the PSA? Yes, come to paragraph 14 and page 16 now.
yes. Paragraph 14 is a, my lord, the guideline of the security agencies. That is, my lord, DGR, my lord. Director General, that is the scheme. How the, my lord, the retired security personnel will be, my lord, the resettled.
Yes,
then, my lord, kindly have a look to, my lord, the Article 14 at page 16. The scheme of the, my lord, I'm coming, my lord.
We are at Article 14.
14, my lord, 14B. The upper age limit of the security guard and the security supervisor.
The word article belongs to the Constitution. You say clause 14,
Clause,
para
I'm
14,
sorry. Yes,
item
yes,
14.
yes. Clause. I'm sorry.
And then when it comes to statute, use the
Yes.
word section.
Yes, I'm sorry.
My lord, may I cut short the matter?
No, please
No,
don't
no.
cut short. You can cut short the matter, but you'll cut him short. We don't know. He would not appreciate that. So let him, yes.
Clause, my lord, 14B, my lord, says that the upper age limit of the, my lord, the security guard and the security supervisor will be 65 years. Appellant number 1 is the security supervisor. Appellant number 2 is the security guard. My lord, this was, my lord, redundant by the, my lord, the respondent number 2 by saying that they, after 60 years, our duty was stopped, not terminated. And, my lord, if your lordships kindly have a look to the annexure, the then, my lord, security agency, my lord, if you love to kindly look to, my lord, page 23. They, my lord, requested. I'm sorry, my lord, I'm coming. My lord, kindly have a look to, my lord, page 24. I'm sorry, my lord. That it is, my lord, written to, my lord, the CWC by the then, my lord, the security agency when our duty was stopped. Referring to a letter number such and such as per DGR guideline, para 4B of the ESM, my lord, the ex-serviceman can work security guard will till 65 years. They requested to re-engage them or not to stop their duties. And this order was, my lord, was not carried out. And thereafter, my lord, we have came before this court. Got it, my lord?
Page number 25.
Page number 25, yes. Page number 25, my lord, that is the order of the appellate court. I came before this court on an earlier occasion, where the division bench, my lord, consisting of Justice Arindam Saha, Sinha, and Justice Subrata.
We don't need names.
I'm sorry.
The division bench is the division
Yes,
bench.
yes.
Why name?
Yes. My lord, their lordship, my lord, quashed that, my lord, the notice and my lord affirmed that the 65 years, the year that to be followed up.
Where is that order?
That is order, my lord, at page 31. The second paragraph, may I read, my lord? For reasons aforesaid, we are unable to accept the position of CWC. Per clause 14 in the memorandum, CWC is to employ security agencies. A security agency named 100% by ex-servicemen. Section 10 in Private Security Agencies Regulation Act 2005 makes eligible the ex-servicemen for engagement up to the 65 years. Appellants are ex-servicemen employed by CWC through private security agencies of said act and
Please
office.
let us read it on our own, please.
Yes, yes.
Yes, that settles the issue. Any appeal against this order?
No. Thereafter, my lord, I filed the, my lord, the.
So you want the same relief as granted by
Yes,
the
my lord.
division bench?
Yes.
That this guy,
What happened in the meantime, my lord, they are going on to recruit, my lord, from outsiders, my lord. And my lord, we are at the verge of, my lord, 65 years. And my lord, without, my lord, doing nothing, without doing any lily activities, my lord, our service was stopped. And we are depriving of having the, my lord, our monthly wages. We are starving.
Yes.
My lord, what my learned friend needs to show is 2 pages thereafter.
Yes.
My lord, there was a contempt application which was
Yes,
referred by the writ petitioner.
Yes.
My lord, that is at page.
You're for central warehouse.
Central warehouse.
CWC.
Yes, my lord.
How do you get out of the division bench order?
My lord, I
MAT 1339 of 20.
My lord, annexure, this is unpaginated, my lord. There is a page 41. Pursuant to the division bench's order, my lord, we had requested the engagement of the writ petitioner through the third-party agency. Now, my lord, how this is engaged is we appoint the third-party contractor who engages workmen and providers at different places wherever the demand rises. So, my lord, we had communicated to them that do comply with the Honorable Court's order. My lord, thereafter, they did not join it. The writ petitioner, there were 2 writ petitioners. The writ petitioner did not join. So, to come out of the stopgap period, my lord, we had subsequently floated a job contract, the subsequent page. Now, my lord, they had preferred a contempt application thereafter. That is page 41.
Yes.
My lord, page 41 is the order which called out of the contempt application. If your lordship kindly comes to the last portion,
Yes.
may be permitted to place it. In circumstances aforesaid, we direct alleged contender number 1 and 2 to ensure that any future vacancy in Petropol is first applied for. Reinstating applicants. Alleged contender 4 will act accordingly. So, my lord, in the interregnum period, there was one Bablu. Well, there was a person who was already engaged at Petropol. Now, there were vacancies in Baharampur and CK Road. So, we requested the writ petitioner that you can join there. But the writ petitioner denied to join these two particular places. So, my lord, as of now, there is no vacancy which has been created at Petropol. Now, he is insisting on joining at Petropol.
Cannot. Cannot.
That is the main grievance.
May I interrupt?
Secondly, my lord, there are
Order
two
sheet, but it
preliminary
shows
objections.
the order sheet, it shows that my honorable division bench observed that we are the senior citizen. We are to, my lord, deploy in the.
Then
That is the observation of the order.
Yes, your argument is contradictory. Here you want to work up to 65, and when they want you to join at Petropol, you take the plea of a senior citizen.
No,
What do you want?
No,
You say, no, I have to continue up to 65. And then suddenly you become old when you're to join at another place. They have a right of choice where they post you. They're following the guidelines. They have not said no.
Kindly consider, this is not the case of, my lord, the transfer.
Then
Without, my lord,
point on affidavit before the
kindly consider, without, my lord,
You have not completed. You please sit down, we'll come back to you.
My lord, two preliminary points which I would be urging before your lordship. Firstly, my lord, in the writ petition, he never sought for a interim order. So thereby interim order was not granted. Now, your lordship, what he's seeking in the application, if that is, my lord, allowed, it will merge with the primary prayer in the writ petition. In fact, the writ petition will become infructuous. So, my lord, he's seeking a final order in shape of an interim relief.
Yes. Yes. Yes, now you can say.
Kindly consider, that's not a case of transfer. My lord, we served the, my lord, the CWC for years together, my lord, unblemished. There was no allegation, nothing. They, my lord, issued the question, my lord, regarding the, my lord, attainment of the, my lord, the years. That was, my lord, declared by the Hon'ble High Court. So, my lord, we should be reinstated in our post. But in the contempt application, my lord, they, my lord, in punishing attitude, my lord, they allotted our duties at, my lord, the far distance from our home. That is why, my lord, we expressed our, my lord, regarding the age, my lord, the Honorable Division bench, my lord, allowed that our prayer, and by saying that as and when the vacancy will be occurred, then you will be appointed. Then we are. But what they have done, my lord, in the meantime, they are going on to recruit the same. Number one. Number two, my lord, the respondent number 2 is the mainly principal employer. My lord, whole duty, whole responsibility is, my lord, burdening to the, my lord, the respondent number 4, the security agency. But security agencies are being appointed, my lord, for the periodical basis. But he is the principal employer.
He is not amenable to writ jurisdiction, really. Security agency has his own freedom of operation. Your right to be employed is with the CVC following the guidelines. The Honorable Division Bench has agreed to your proposition. Yes, you can continue up to 65. When you went in contempt, the concurrent division bench said, no, you go to somewhere else where they are posting you. Otherwise, you wait till a vacancy arises. So wait.
And the only offered was.
You cannot force them to give it to you.
No, matter in the meantime, they are
already
they are going on to recruit. But there are where the vacancies. They are recruiting by violating the court's order. That is I'm before your lordship, my lord. They are going on to recruit, my lord.
My lord, during the
I have already, my lord, annexed.
My lord, I am for the respondent number 5, my lord, the security agency, my lord. I recruit only for the reliever duty, my lord. There was no permanent employment. Only the reliever duty. I offered, my lord. If you kindly, your lordship kindly come to paragraph page.
I think it's nothing but evading, my lord. They are, my lord, the duty was CWC is the principal, and kindly consider this. They are violating the, my lord, the DGR guideline itself.
Please take your seats.
May I submit another thing, my lord?
Please take your seats.
My service is terminated since, my lord, from the December. I am not in the.
May I submit, my lord, one thing, Yes, my lord, central.
Question is, you stop them from working.
My lord.
Let my learned brother frame the question for you. Please, please take your seat first. We'll come back to you.
These two appellants were initially working at Petropol.
My lord.
They were stopped
My lord.
there. Thereafter, other persons have been attached to at Petropol.
My lord.
What for they have been stopped? And the reason for the stoppage?
Well, initially there was a conception, there was a wrong conception. I concede to that. That
point is, that is, I'll take the question further from my learned brother. But the point which is that they were stopped. They came to court. Court decided in their favor. They came in contempt. The court decided in their favor. Of course, in the contempt application, they have been asked to join. The question is, if you have stopped them and the court said, no, you cannot stop them, they must go back to where they were.
I appreciate.
How do you take the plea? Now you have no vacancies.
No, my lord. Dude, I tell you, lordship.
The status quo ante should come back.
I appreciate.
Then,
my lord, the difficulty is that when we have already appointed someone as a reliever duty there, we had requested them. One of the meat of the matter is the writ petitioner wish to join only at Petropol.
You cannot do something which is frustrating the order of court.
My lord,
court told you to follow the guidelines.
My lord.
Court told you other things don't matter because the guidelines have a specific. So the court said, therefore, they are set aside. Your action of stopping them is set aside.
My lord.
Now, of course, when they came in contempt, court agreed with you that if you have a vacancy, give it to them. But the question is, are they not entitled to be put back into the same position when they won before the first court?
My lord, that plea my learned friend could have taken in the contempt jurisdiction, saying that the order may direct me to directly join. That plea was not taken.
So how we will ask you to speak. Yes. Please let the court proceedings carry on in a manner where everybody can be heard. Now tell us one thing. Then what did you do when you stopped them? Whom did you appoint in their place? Relievers.
Relievers, my lord.
So now what do you do with these relievers? Relievers are relievers. They can be relieved.
My lord, it is a temporary employment. It is not a permanent post. It's not a permanent employment.
Then the relievers will go after a point of time. That vacancy will arise.
Yes, my lord. We had also told the writ petitioner to join as a reliever, but he doesn't wish to join as a reliever too.
Because why should he? Because his entire emoluments will go down.
That appointment itself is not a permanent appointment.
What was his earlier designation?
My lord, security personnel.
Then?
Also, your lordship kindly comes to the affidavit. The writ petitioner is 64 years old in 2022.
There are no questions asked till that he continued up to 65.
My lord, the highest age limit is 65.
Correct. Nothing can be done up to 65 since you have not appealed against the order of the honorable.
No, my lord, I did not appeal because my lord, the liberty was given to me that if a vacancy arises, then I will appoint him.
Vacancy will never arise till he turns 65. Then what happens? His entire list becomes infructuous.
My lord, that order is also not challenged by my learned friend.
We try to clarify it for the ends of it. You have to devise a means to get him back because the order has to be. You cannot.
My lord, let it be decided on the affidavits, my lord.
He'll retire. He will become infructuous. What will you pay him?
My lord, anyway, from the date of disengagement, he is not. He has not even asked for any other release, my lord. If your lordship takes up the writ petition. Now, the difficulty is he wishes to work with the central warehouse. We had given him two options to join. The distance, my lord, from his place to Petropol and also to the place where he was sought to be joined, he was asked to join, is also not very different. They are almost similar. So those places he did not join. He only wishes to join a Petropol.
We do not like to use that word. That was slightly mischievous. That was, we do not want to use that expression. It should come from a lawyer, but that was mischievous to frustrate the intention of the court.
But my lord, we had acted pursuant
Yes,
to
the security
which is
agents,
passed
no.
in-
You do not have
Okay.
permanent relievers. You find out ways and means that they can be appointed and come back to court. Because this way, you find that he is not important.
My lord.
It's not a person who is important. The appellant and writ petitioner, they have their individual fates. What is important is the order of the court. This, of course, in contempt, the court said put them there. But the question is that their order was passed in 2021. Today we are in 2023. It is surprising that you still do not have a permanent vacancy in.
My lord, as far the present condition is concerned, my lord, I shall take instruction on that. I'll come back tomorrow. I'll take
Yes.
instruction on that.
My lord,
Because of the simple reason,
I
anyway,
appreciate
this
what
whole
Fox saying,
writ
my lord.
petition is becoming infructuous, and you will not be bearing their burden beyond 65. One is 64 plus, and the other is how much?
The other has not preferred any writ petition.
It's only one before us.
Only one writ petitioner.
We are representing only one appellant.
Two applicants, they are nearing to 65. They have not yet
Both
completed
affairs.
the 65, but they are nearing to 65.
So you're not going to carry them carry their cross on your shoulders for long. Yes, that's
my
what
lord.
number 5.
Respondent number 5 joined in service, my lord, received the service order, work order on 1st April 2021, my lord. I provide service, my lord, for the serviceman, my lord, and my lord, kindly come to page 41, my lord. This is the order. Kindly come to page 40 to the last part, my lord. In circumstances aforesaid, we direct alleged contaminants number 1 and 2 to ensure that any future vacancy in Petrapol is first applied for reinstatement applicants. Alleged contaminants 4 will act accordingly, my lord. Thereafter, my lord, I being at that point of time being the service provider, I send a letter to the landed advocate, my lord. Kindly come to page 43, my lord. Please refer to the direction of the Honorable High Court at Calcutta, dated 29th September 2021. In compliance of the order, CWC RO Kolkata had allotted 1 vacancy each at CWC CK Road and CWC Behrampur to reinstate Sri Sajal Pal, the appellant's, my lord, and Sri Sudhanshu Kumar Sarkar. Joining letters to both of the individuals were forwarded on 29 September 2021 by Colonel Sandipan Das, proprietor, photocopy annex, my lord. However, both the individuals refused to receive the letters as per the remarks endorsed by the Department of Post and Telegraphs, which were returned to the sender undelivered. At present, the only vacancies existing at ICB Petrapol is of relieving duty, my lord. We offered, my lord. Thereafter, this translates into 11 duties in the months of with 31 days and no duty in the month of 30 days, my lord. In case such relieving duty is acceptable to your client, namely Sajal Kumar Pal and Shri Sudhanshu Kumar Pal, they may be directed to submit their documents at the office, my lord. But they did not, my lord.
Kindly see the next page, page
Yes,
44. One
Yes,
Bimal Kumar Biswas has been appointed in permanent capacity at Petrapol. Now, these facts are not.
They are relievers, my lord. Sajal Kumar Biswas was the reliever, my lord.
As security guard, permanent appointment.
Please refer to that the director appointed Sajal Kumar Pal as security personnel at CWC Petrapol Bundgaon as when the vacancy will occur. My lord is on what page, my lord?
Page 44.
Yes, my lord.
There is an email addressed by their lawyer, Mr. Obijit Sarkar.
Yes.
Kindly see the middle portion or the first portion.
Take note the Sajal Kumar Biswas
Came to my notice that recently Bimal Kumar Biswas has been appointed as security guard at CWC Petrapol, which means this was a future vacancy. You're in contempt of that order.
No, my lord, there was no
case this
future
is correct.
vacancy, my lord. There are only relievers vacancy, my lord. Only relievers vacancy, my lord.
Yes.
And my lord, one thing, my lord.
How
from
far
December,
from 1 minute, please. Yes, tell us, yes.
December 2022, my lord, my service has been terminated, my lord.
So you really are not part of this
My
list. And how far are these two places, Mr. Council? Baharampur and CK Road?
My lord, my instructions, they are almost similar to that of until Petropol. From his
That's
place
right.
till Petropol.
How far are they?
My lord, as far as
Distance?
almost 50 kilometers, my lord. I tell your lordship very candidly, my lord, this should not go on record.
Yes.
The reason why he's wanting to join at Petropol is that the reason is something else. Nothing else, my lord.
You could have terminated them earlier. on that
Difficulties, my
day.
lord.
Something else,
The difficulties, my lord, the difficulties, I tell you, lordship, is because we had sought for a report from the third-party agency. We had sought information, but that would go as a taboo, my lord. He's almost
That will go as a
taboo for his further engagement. So that is why I said,
show us the report.
my lord, it's a
ask.
very informal report. I don't have it now, my lord.
You file it in the form of an affidavit.
Well, it's a very informal report, my lord. Just the reason.
But it should not be a manufactured report.
No, my lord, it is not. Absolutely. That is why I said, my lord, candidly, this should not go on record.
Very well. Then show us the report on the next date.
Well, I will ask, but it was an informal report. It is not a formal report. Which is
They are guilty of corrupt practices at the border. That is the report.
My lord, it's not a report. In fact, what was sought for was the reason why he's there and certain activities which were done. So, my lord, that's the very reason at the outset I said, my lord, this should not
Show
go on.
us the contents of it.
I will ask for it, my lord. I'll ask for it.
Ashu, taking it. That is why you say they want to only continue.
Only continue at Petropol.
So you could have used that report or whatever and said, no, we are
My lord,
posting you outside. Why
then-
did you have to wait for a legal pronouncement on
My
the
lord,
subject?
The then regional manager did not want to disclose that because it would go as a taboo for his further employment.
My lord, the illegal steps, my lord. They should have, my lord, diverse the on earlier location.
Anyway.
But my lord, this should not go on record.
No,
It's a request.
Party are represented in the order of their name/name. You will turn 65 by this litigation is over, and then nothing will come your way, because after 65, no court can even grant you any appointment, and you cannot claim arrear wages also, because if you have not
put a question to myself, my lord, why
keep
don't I?
asking questions to yourself.
Only, my lord,
We will do our job.
No, my lord. Yeah, after 65, I nothing to say, my lord.
Nothing. So we wait.
Only regarding the. First of all, my lord, your lordships already hold that they did not do in accordance with law. Number two, my lord, then we are
No, but they are not out of law also when they ask you to join at a place of posting.
What I am on, my
that is why these
they tried to, my lord, dishonor the courts order.
No, they have not. In the contempt, you have not succeeded. They have definitely not. They would have dishonored the court's order if in the contempt you had succeeded. Contempt you have failed.
My lord, kindly consider only the redressal, my lord, there will be, my lord, without having any unblemished service, my lord, we are depriving our wages.
They are going
we
to
are entitled to get the arrear wages from the, my lord, the principal employer. That is before your lordship. This is my lord, humble, my lord, prayer before.
No, file a second writ petition, go before the industrial tribunal. We are confining yourself to your present engagement. Moment you turn 65, we are out. We are done with you. Parties are represented in the order of their name/names. You can advise your client intelligently, see what they want to do, or continue with this litigation. Anyway, before the single bench, the affidavits, try to file your affidavits. We could have sent you back now to the single bench. We are trying to find out a solution if possible.
Your lordship, correctly, my lord, that after 65, you don't have it.
Yes.
So, my lord, what they have done in the meantime, only before your lordship, that illegal activities, my lord, they should be, my lord.
Heard, full stop.
We have been harassed. Now, for the first time, my lord, they are raising the point, my lord, we are the corrupted people. For the first time.
The central warehouse, CWC, is permitted to revert with further appropriate instructions on the next day. Also, let the matter appear under the same heading. Mention matters in the combined monthly list of May 2020.
The fact is, by the previous regional manager, he was also an ex-serviceman. He did not want to cast a blemish on an ex-serviceman from the army.
Give us the report in a whatever. So share the report with us.
Very well,
Your input, and then only we can take a call.
Lordship gives me a week's time, my lord.
May mention matters.
My
lord.
Deeply obliged.
My lord, the respondent number 5 has to file any affidavits, my lord.
No.
My lord, my name may be expunged, my lord.
Not now.
My lord.
Not for your sake at least now.
My-
High Court Act fix it.
I am appearing on behalf of the appellant. On the basis of, in terms of your lordship's order, on 16th March 2023, the school committee have taken a resolutions and the relevant papers and also the copy of the resolutions.
Lordship.
Take- I am appearing on behalf of the appellant. In terms of your lordship's order on 16 March 2023, the school authority adopted resolutions, the copy of the resolutions, and along with other relevant papers, staff attendance registered, a report of DI of schools. It was forwarded to the administrator, West Bengal Board of Secondary Education.
There is no
It was
administrator.
sent,
There is a president.
So what remains?
it was sent on 27 March 2023, and it was received on 30th March 2023. I'm handing over the bucket copies. Thereafter, the board issued a letter on 30th April 2023, and it was received by the school authority, headmaster of the school, that is the appellant, on 18 April 2023.
Whether the leaf portion has been rectified, leaf portion, the
Lordship,
concerned person.
Yes.
Lordship, they have
Yes.
taken a resolution, but in the resolution, they have not decided whether that leave will be without pay or not. They have, kindly come to the last paragraph of the resolution. May I read? On the basis of the aforesaid documents and also on basis of the available documents in the school, our present managing committee members have taken a resolution unanimously in this matter that late Pratap Chandra Shahu was absent in the school since 1990 till his last day of service. What is the date? That has not been written. Without any leave application or intimation to the concerned higher authority. But what resolution they have taken?
But
they will have, because it is to be to the managing committee to take a resolution whether they grant the leave without pay or what is the decision. That is the reason the board has sent a letter to them stating that resolution asks for the resolution of the managing committee mentioning dates from 19/12/1990 to 31/5/2023 as leave without pay. Paragraph 3, serial number 3.
It was issued on 13 April 2023. I received the appellant.
It's an incomplete resolution, Your Lordship.
The appellant received the letter on 18 April 2023. I have handed over I have annexed the copies of staff attendance registered and photocopy of the report of the DI schools, which was issued on 19 July 1994. 1994. Your Lordship.
We need a resolution of the managing committee, their decision, because board cannot decide on its own. It is.
So
this is
have you taken a resolution of the managing committee?
But it is not clear what they have decided. They have only said that he is absent from this date till his retirement. Even
So what have you,
Copy has been received. No applications for leave has been received on by the school authority on behalf of the ex-headmaster.
on the microphone, Mr. Shah.
This is husband of the petitioners, of the appellant, and the report, I have already annexed the report which was issued earlier in the year of 1994. The DIF schools, your losses once for a moment. And the board of
considering all these things, let the managing committee take a resolution. They want to grant leave to the petitioner without pay or with pay, whatever they decide. Let
it will
them
be
take a
submitted.
decision and send to us.
2 weeks has been given to submit that documents before the board. Accordingly, it will
We
be
should have done
submitted.
it previously only.
It has been read by the.
It is not available.
This is impossible.
authorities.
Mr. Shah, your headmaster, it
Most
is
difficulties is that the appellant joined in the school in the year of 2007. And
we have
the
heard that
thesis
story
is-
before. We have heard that story before. After that, 2 orders have come from this court.
Yes.
Why are you not accelerating the process? Why are you taking time? And again, this is a widow who is not getting a family
I have
pension.
every sympathy.
Then something has to be done about you now.
Yes. A resolution has been taken and it was forwarded to the board and
Stop the salary of
Yes,
the
yes.
headmaster from
no.
stop the salary of the
I
headmaster
stop
from
it.
this month
Your losses
till the matter is resolved. You
DI,
who
direction upon the DI.
stay DI and also the board.
Board doesn't disperse the salary. It is the
Yes.
DI who disperses the salary.
Yes, stop the
No
salary from
documents
this month.
has been-
We will look into the matter as and when we get the
in my
result.
stay application, also in the appeal, memo of appeal, I have categorically stated no documents has been lying before the court, before the school authorities. All documents has been taken away by the
What else?
ex-headmaster of the school. That is the husband of the applicant, husband of the petitioners.
Correct. You have
That
to.
is that is the.
Please wait.
I'm totally handicapped.
Yes.
I joined there in the year of 2000.
Your Mr.
School authority, previous school authority did not take any steps to hand over the documents to the
You have to take a
appellant.
resolution. You have to take a.
I am victimized.
You have to take a resolution.
School committee has taken a resolution.
I
I'm
have
the
not taken
headmaster
a
of the school.
resolution.
I'm the headmaster of the
Where have
school.
you placed the resolution? Show us the resolution of the managing committee.
I've already handed over the resolution.
Is that a
Copy
resolution?
of the resolution.
Which resolution?
Yes,
Just-
yes, yes,
This,
yes.
well, it kindly says last paragraph. No decision has been taken by the managing committee.
First page, first
First
page of the
page.
bunch of papers. First
First
page of the
page
bunch of
bunch of papers, yes.
I'll send the documents to the Board of Secondary
Board
Education.
will decide whether it will be leave with pay or without pay. It is the managing committee decide.
It
Well,
will
that
be
is last
submitted.
paragraph.
Only a simple clarification from the school is required whether they are sanctioning the leave without
will be
pay
submitted
or
With
with
pay.
pay.
Only one
Only a
line.
simple clarification, one
Yes.
line clarification.
That
And they are sitting on that for so long.
It will be submitted within 7 days from your lordship, from this date. Your lordship kindly pass this order.
Today is what date?
I'm totally handicapped.
You are going to be further handicapped by order of court.
Actually-
Go up in appeal, go do whatever you want.
Actually, no
We can
documents.
assure you that. You are
Actually-
handicapped now, you'll be further handicapped. Mr. Shah, with great respect to you, your defense of your learned counsel, for your client, you will be handicapped. You're handicapped now, possibly you'll be further
I'll take
handicapped.
steps to submit the documents. Your lordship, give me
When can you
time.
come back before this?
Within-
What do you need? Please tell us, because
10
we have been
days.
at this matter. This widow has not been receiving salaries or whatever pension. For how long you have not been receiving?
We have prepared the pension service book.
We have been trying to assist the process, and the school is coming in between, and
Within
now
10
we are
days,
not.
Your lordship, kindly grant me in 10 days. I will send all the papers.
We are giving you a date. Come back with that resolution. Exact. What is the remaining
Well,
document, Mr. Bari?
only
Only
one
one-
thing, it is an admitted position
Was
of
there-
fact that the person was absent from this period to that period. Now, my lord, there is no application whatever. Now, the resolution of the managing committee is to be to this effect that they approve
leave
the-
without pay.
as leave without pay or leave with pay. Whatever they take a decision, they will take a decision in the resolution and send it to the board, and board will accordingly approve that resolution.
Within 10 days, your lordship.
That will be obviously leave without pay because he was not, he was absent for a long period of time. Only one, but they have not taken the trouble to do it. They have only said he is absent. Even the date, from which date to which date absent, that has also not been written in resolution
That
till
is
the end of
different.
his service.
It will be corrected and send it.
Blame.
Your Lordship, give me
1 minute. Yes, Mr.
10
Bari?
days.
But we only require the sanction of leave. Other things are complete. my
All
lord.
things are
Yes,
complete.
only one resolution will
Only-
be sent
only-
to the board.
only
we
sanction
will
of leave.
sanction the leave.
In which period is
66 to 90, husband of the petitioner work in that school.
They will have to take a resolution.
Only
Only
after
resolution.
90. my lord,
Leave
the-
without pay, only one word.
Yes, that's true. Your Lordship,
We
give me
meet,
10 days. Yeah, understanding full coach.
we meet on the 27th. That is next Thursday.
Well, wait.
27th, next Thursday. First matter in the morning.
10 days. Your Lordship.
No, we are not going to give you 10 days. We are going to meet next Thursday. You arrange your functions. You produce the resolution in court. We shall formally hand over to the court.
Lordship.
And then her pension should be ready.
Lordship.
Ashok. Otherwise, we take, Mr. Shah is appearing, we give him one more charge. Otherwise, it's not you. Otherwise, your headmaster, after 27th, faces penal colleague, including the secretary of the institution. Parties /are restrained, appear in the order of the names as printed above in the cost title. Full stop. This matter, this court has been in scene of this matter for several dates in the past. Full stop. The issue involves the disbursement of family pension of a widow whose husband was a former school teacher. Full stop. Due on the basis of several court orders passed in past after hearing the parties who are present today, who are also present today, this court is informed by Mrs. Bhattacharya, learned counsel appearing for the West Bengal Board of Secondary Education, and Mr. Bari, learned counsel appearing for the District Inspector of Schools.
I am led by Mr. De.
Yes, of course. District Inspector of Schools within bracket Secondary Education,
Fine.
bracket close. Which district?
Paschim Medinapur. Purva Medinapur.
Purva Medinipur. Mr. Barik is led by Mr. De, Jawaharlal De, appearing for this Purva Medinipur, that all documentation connected to the disbursement of the family pension to the respondent number 1 / the writ petitioner are ready, have been prepared, are ready, have been prepared, except the resolution of the managing committee of the school in issue, clearly indicating what will be the language?
Sanction the leave without pay.
Clearly indicating the sanction of the leave
Without pay.
with or without
With
pay.
or without, that is their decision.
Sanction of the leave with or without pay of the deceased husband of the respondent number 1 / the writ petitioner. What are italics and bold within bracket emphasis applied. Full stop, bracket close. Full stop, para. Mr. Shah, learned counsel appearing for the appellant, assures this court that the document shall be produced on the next date. Full stop. That the necessary resolution of the managing committee shall be produced on the next date. Full stop. Accordingly, para. This court is also informed that upon production of the document, upon production of the document, the same can be handed over to the District Inspector of Schools SE for taking consequential steps in consultation with the board for final.
Handed over to the board, the landed board, and board will approve sanction the leave and it's sent to the DI.
Necessary consequential steps can be taken in consultation with the board to finally disburse the pension. Full stop. This is a widow pension. We are on the job from several dates, and we are in no particular mood to delay the process anymore. And we make it clear to the headmaster. Let the matter return under the same heading mentioned matters at the first sitting of the court at 10:30 a.m. on the 27th of next Thursday, 27th of April, 2023. Full stop.
Lordship.
All parties to act on a gist of the communication of this order, all parties to act on a server copy of the documents filed today be retained with the record. Mr. Shah, you're not only representing your client, you, of course, you're very experienced, you're also an officer of the court. Judgment আছে আরেকটা ম্যাটার আছে কি যায় there's a judgment on the original side, so we'll deliver the judgment.
My lord, before lordship takes up the original side matter, my lord, may I be permitted to
Louder,
mention-
louder.
My lord, may I be permitted to mention item number 11 of today's list, my lord?
Yes.
My lord, may it be taken up next Thursday, my lord, because 1 week, my lord, I have some personal difficulty.
You have told that. Who appears for the other side?
I'm for the applicant.
Next
Appear for the
Thursday.
respondent with petition. Next
Mr.
Thursday.
Dole, next Thursday. She is in difficulty. She has mentioned any urgency.
Lord,
No,
we have
the
contempt
contempt
is
proceeding is going on, my lord.
Next Thursday by date.
My lord.
grateful, my lord.
Please see that the contempt is not.
No, we'll not.
That is also because since you are not in the appeal, don't be in the contempt also.
no.
Expected you'll take time. there.
Yes, ma'am.
Next Thursday by date.
Grateful, my lord.
May I have my lords kindly to totter the same line, my lord. I have similar prayer, my lord, with regard to item number 10, the next matter. Mr. Bari is appearing, my lord, in this matter. Can we come back on next Thursday if it
Yes.
your lordship?
Bimal. ঠিক আছে? 10 and 11. Next Thursday করতে. Mention matter.
Item number 10, my lord.
Madam, where is Mr. Dole? Kota matter আছে next Thursday? Mr. Dole, please come forward. 1 minute. Mr. Siddiqui, please give us a moment. Fixed. এই দুটো তাহলে মেনশন ম্যাটার বাই ডেট হয়ে যেত শুধু মেনশন mention matters retaining his position next Thursday.
Yes, sir. We are extremely grateful.
Not by date, retaining his other matters are fixed. But please, if you have any difficulty with the contempt, come and mention before this court.
No, my lord, I will, we will mention.
Come and mention upon notice before this.
Grateful.
Yes. Next Thursday, কি দিন পড়ছে 27 Judgment ডাকতে বল Yes, there's a discussion on the statutory provisions which you have argued. I read out the operative portion.
Very
for-
well.
for- Having heard the parties and considering the materials placed, this court is at the threshold required to notice the statutory position governing the field. First, the designated judge of a high court shall have the power to try an election petition under section 80 capital A of the 1951 Act. The grounds on which an election petition may be presented have been specified in section 100 of the 1951 Act. The involvement of a returned candidate in any corrupt practice shall be one of the grounds for declaring the election to be void under section 101B of the 1951 Act. The contents of the election petition are specified in section 83 of the 1951 Act. The High Court shall render a decision in the election petition under section 98 of the 1951 Act. While passing an order under section 98, the High Court shall be eligible to pass other orders as specified in section 99 of the 1951 Act. Sections 98 and 99 read as follows. We have quoted that. The procedure for filing an appeal is provided in section 116, capital C of the 1951 Act. Upon a close examination of the provisions of the statute, that is the 1951 Act, this court finds that appeals under section 116 capital A shall lie against orders passed under sections 1998 and 99 supra. Admittedly, the trial of the instant election petition being EP2 of 2021 could not be held by the Honorable Single Bench. Therefore, there could be no reason to conclude the trial as ordained by section 98 within brackets supra. Consequently, no decision could be rendered by the High Court at the conclusion of the trial, dismissing the election petition and or declaring the election of the returned candidate to be void and or declaring the petitioner or any other person to be duly elected. Since no decision could be rendered at the conclusion of the trial, no other orders connected to the trial could be passed by the High Court under section 99 of the 1951 Act. Stricto sensu, therefore, no appeal could be filed before the Honorable Supreme Court under section 116 capital A of the 1951 Act, which provides for appeals from every order made by a High Court under section 98 or section 99 supra. For the benefit of this discussion, section 116 capital A stands quoted below. We have quoted 116 capital A. Clause 15 of the letters patent also contains no specific bar against an intra-court appeal from any other order in an election petition, which is not an order under sections 98 and 99 of the 1951 Act. Clause 15 of the letters patent reads as follows. We have quoted clause 15. This point came up for discussion in 2012, volume 12, SCC, page 27, wherein speaking for himself, one of the honorable judges observed as follows. We have quoted from that observation. Applying the same logic to the order of the Honorable Single Bench, which purports to dismiss the election petition based on admission of facts and in exercise of powers under Order 12, Rule 6 CPC, such a dismissal not being an order passed under Section 98 and 99 of the 1951 Act, arguably is amenable to an intra-court appeal under Clause 15 of the letters patent. However, at this juncture, this court must notice the clear pronouncement of the Honorable Supreme Court in 1988, Volume 2, SCC, page 1, at paragraph 16, 17, 18, and 19, which reads as follows. We have quoted extensively from that. Having regard to the above discussion in 1988, Volume 2, SCC, page 1, this court cannot have two views on the entire procedure connected to an election petition being part of a single statutory framework. The period of limitation specified in the 1951 Act for filing an appeal to the Honorable Supreme Court also indicates the statutory intent of maintaining a single framework for conduct of election proceedings. Therefore, arguably, though the order impugned of the Honorable Single Bench is not an order under sections 98 and 99 of the 1951 Act, but at the same time, an order dismissing an election petition. Accordingly, having regard to the pronouncement of law as laid down in 1988, Volume 2, SCC, page 1, supra, orders, even if considered incidental to an election petition, but have resulted in an adjudication of such election petition, must be restricted to a particular channel of appeal to the Honorable Supreme Court, having regard to the overall statutory intent of keeping disputes connected to the electoral process under a consolidated adjudicatory framework. Before parting with the discussion, this court must also notice the admitted facts relied upon by the Honorable Single Bench, gathered from the pleadings on record, which are part of the contents of an election petition disclosing material facts and covered by Section 83 of the 1951 Act. Admittedly, therefore, the Honorable Single Bench has considered such material facts and dismissed the election petition. Fundamentally, therefore, the dismissal of an election petition is only amenable to a challenge as provided by Section 116A of the 1951 Act or by way of a special leave petition under Article 136 of the Constitution of India. APOT 95 of 2022 stands accordingly dismissed as not maintainable.
In that case, my lord, if I may pray for a stay of that particular.
Later. Stay of the order is prayed for by Mr. Shengupta, learned counsel, appearing for the appellant. Full stop para. Prayer for stay is considered and refused. Full stop para. Yes. Anything more?
The stay would have been to approach the Supreme Court, but nonetheless,
Very, very well.
great.
Sorry, Mr. Shengupta, but the discussion is there. You are always, you can subject.
Has your lordship, in the judgment, because I could not produce the judgment in entirety, there was a direction, upon the election commission to decide upon the.
We have not gone into the merits.
Gone into that. Very,
We have said it's not maintainable.
very,
The appeal itself is not maintained. Merits are honorable.
very
But
grateful.
Thank you for the assistance. It was a new field of discussion and we were well assisted.
Grateful.
সার্কিট লেখুন এটা সার্কিট লেখুন তুমি সার্কিট 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 I was mentioning one matter.
Yes.
It was mentioned earlier and matter was directed to appear today in a contempt, your lordship.
It was mentioned, it was not directed that it will appear today.
No, my lord, I gathered the information. Whenever the court sits, it will. Anyhow, my lord, I'm mentioning once again that order has been fully complied with. And my lord, that gentleman is under suspension. It is a little bit urgency. Let it appear. Special officer payment. And my lord, payment of the special officer has been done.
Give the slip.
Yes.
Ask you Leonard Junior to check from our court officer.
Ben.
Any other date.
Get. May I pray for Lordship's leave to mention this matter? Now, this was mentioned and it figured in the list of 30th, since the bench didn't sat on that day. Today it was intended to be flashed, but I find this is disappearing from the list. Let's kindly take it up on the next week itself.
It is.
No, this assigned matter already heard is actually in the verge of completion. 25 years I'm on suffering. Their admitted position, persons who ought not to have been over there is gulping my bread and butter. I will only take 10 minutes for disposal. Only 10.
Gulping.
Gulping. Only 10 minutes. So she kindly give me and I can dispose of the matter. Already Lordship asked me to prepare the compilation. That was also.
If you take away the bread and butter, how will he live?
No, my bread and butter is being taken away. He has already done his job on the verge of superannuation.
Very well, let us.
Grateful, my lord. Kindly take it over next week.
Is it partnered to no?
Yes, partnered.
Oh, then it's
partnered, assigned partnered. Already heard. Great.
Yes, Mrs.
I am for the appeal in this one.
I will state this one.
Quickly. Notes have been filed.
My lord.
Just give us a refresh on your points and then we shall put it back. Mr. Banerjee, yes, you are the appellant. What are the primary issues?
My lord, kindly have a look at my
them.
written notes of argument, my lord.
Here's your file. Respondent number 3. Who is the respondent number 3?
High Court.
And state is there. Mr. Debroy is there. You do not have anything to add to this.
No, I am not adding. My lord, I am adding.
Primarily between both of you. Yes, Mr. Shamanto, the main points.
My lord, kindly take up my written notes of argument, my lord.
Yes.
Already. I filed it earlier, my lord.
Is this the written notes?
My lord,
Compilation?
short compilation of index.
That is the written notes?
My lord.
Okay.
My lord. Well, before I start, my lord, I beg to state two things, my lord. There are two typographical mistakes in my written notes, my lord. Kindly correct me, my lord. Page 2.
Yes.
Page 2, my lord, in the middle portion, the primary cause of action.
Yes.
The date has been written as 27th of June 2012. It will be 27th of July. All the applicants joined their service on 1st August 12 for the post of peon by order number 169 dated 27th June 2012. It will be, my lord, 27th of July 2012.
Yes.
And the second is page 16, 16.
Yes.
the first line, my lord, relevant paragraph number 31 of enclosure X4 has been written, it will be X3.
Yes.
And my lord, in all the cases, instead of respondent number 5, I have written in respondent number 4 in all the pages, my lord.
4 will be 5.
4 will be 5.
Good that we kept it as to be mentioned today. Because otherwise, this clarification would not have happened and we would have proceeded that 4 is doing the whatever is wrong and 5 is whatever.
I'm grateful to Lordship, Lord.
We are
Lord.
grateful to the Almighty. 4 will be 5.
Will be 5.
The others are, of course.
My lord.
Yes, Mr. Samanto, the brief, the main point.
The brief, my lord, the petitioners joined the service on 1st August 12 as a group D, and their service was confirmed on 1/8/14 with effect from 15/11/14. And in the meantime, a notification was issued on 1/9/14. Prior to that, my lord, this honorable court circulated on Geo number 5140 for the post of for the promotion of the group D staffs. And the notification was issued without, in contrary to that guideline, which was circulated by this honorable court in terms of the city commission recommendation. The 1/9/14 notification was issued without following that guideline, my lord. And when the 1/9/14, they tried to they started the recruitment in respect of the 1/9/14 guideline or notification, I was not taken into the consideration of zone of consideration. As because they say that your date of confirmation is 15/11/14, but with respective effect, with effect from 1/8/14. And that's why I was not taken into consideration. That's the primary cause of action. I raised the grievance and the notices were, demand justices were there to my employer and to this honorable court, and but nothing was considered. And the second cause of action, my lord, the regulation says the district judgeships and the judgeships are required to publish their gradation list on each and every year in the first month of the year. But what happened in this case, my lord? In 17, they published the gradation list of 15 and 16. No, I stand correct. On 16, they published the gradation list of 14 and 15. And 18, they published the gradation list of 16 and 17. And where I was placed below some persons who were actually or who ought to have been below me in the gradation list. But I had no occasion to raise any objection regarding that because the gradation lists were not published according to the notification in the month of January and each and every year. I raised this point also. And though these were not considered, I came up before this honorable court in a writ petition. The writ court did not consider my preliminary objection, the first point regarding the non-compliance of the GO. The second point was considered and said you were debarred due to estoppel and waiver because in the 16, when the 14-15 gradation lists were published in 16, you did not raise any objection. When the 16-17 published in 18, you give the objection. But the thing is this, when the 14-15 gradation lists were published in the year 16, they are the only avenue for correction of date of birth and the name, typographical error in the name. And nothing was there. So I was diverted from correcting all these things. In 18, when the gradation list of 16 and 17 was published in the year 18, I raised all the objections. But the court, the first court was pleased to dismiss on the ground that no, you did not raise any objection in 16. So you are stopped from correcting this. And dealing with the second point, the writ has been dismissed. May I place the order implement, my lord.
Yes.
Before that, my lord, kindly have a look at page 137 of the paper book.
Paper book was also removed. Yes.
My lord. 137.
Vimon. Corridor বন্ধ হয়ে গেছে। Yes.
My lord, the type page is 137A. Type page.
Yes.
To all the district judges, Lord Chief, including the Chief Judge, City Civil Court, President Small Court, subject implementation of the recommendation of the City Commission in terms of the order of the Honorable Apex Court in respect of judicial staff of the subordinate judiciary. With reference to above subject, I am directed to say that in terms of the direction of the Honorable Apex Court passed in All India Judges Association, GO number such and such 5140, 514, and all dated 27th of July 2009. JDM dated such and such have been issued by the state government for implementation of the recommendation of City Commission, copies of which have been sent to you from the governance end. Accordingly, I am directed to request you to kindly intimate the undersigned as to whether the recommendation of the City Commission as contained in the information given on this have already been implemented or not positively by written facts. I am further directed to request you to take necessary steps to implement the same with retrospective effect if the aforementioned GO notification have not been implemented, Registrar General. And the GO is in the next page, my lord. (138).
Yes.
From to subject implementation, sir, in compliance with the direction of the Honorable Supreme Court in India, dated such and such, my lord. I'm coming to the point, my lord. Point number 1, the process establishment in Mufasil courts D.
What do you want? You want a promotion to Group C.
LDC.
LDC, which is the Group C post.
Group C post.
Now, where are you affected? By in which part of the gradation? Let us break down your arguments. Yes, tell us what happened. Then what happened? When were you left out?
I was what happened?
You are in Group D, continuing as
Continuing
Group
in
D.
Group D.
They announced the promotion process for Group C.
They publish a notification.
Yes, on which date?
On
which
1914.
Then what happened? Don't look at the papers. Let us break down your arguments.
What happened, my lord? In that notification, they only published the for the direct recruitment, not for the promotional revenue was not there.
Yes.
So in this notification and the GO and the circulation made by the notification made by this honorable court, there was an avenue that 25% will be left open for the promotional person.
Correct.
The persons who are in the service, the lordship knows the in service duty person, they ought to have been promoted when they are in service. Their avenue must be kept open. But that has not been done here.
By the 1/9/2014 notification.
My lord.
Then next what happened?
Well, I was debarred.
Yes.
I was not permitted to participate in that.
Yes.
Well, I raised objection. That has not been considered.
When did you raise objection?
Immediately after that, my lord.
Then?
That has not been considered. I came to the writ court. That is the preliminary point of my writ petition. And the secondary is, my lord,
No, we have not completed the first point.
my lord,
Then you came to the writ court.
my lord.
What happened in the writ court?
That has not been dealt with. That point has, the respondent appeared, they filed their opposition. They did not apply their mind on that point and did not raise any objection with regard to that event.
What did the writ court do? Did it apply its mind?
No,
Then what is the fate of that writ?
the writ has been dismissed. That point has not been discussed.
And that is the closure of the writ. No appeal, nothing.
This is the appeal.
This is that appeal
My lord.
again. So that writ, this is the appeal.
My lord.
Now next what happened?
Next, my lord, the gradation list. The gradation list for
Yes, then
2 points have been urged in the writ
My lord,
petition.
my
The
lord.
first point has not been answered by the writ court.
Writ court.
And the
Second
writ
point has been negative.
dismissed on the second point.
On the second point only.
On the issue of the gradation list, because you have not challenged it in 2016.
That was the writ court's order.
very well. Then next what happened?
Well, in the gradation list, 2016 a list was published with regard to 2014 and 2015. Only there was an avenue for correction of date of birth and clerical mistakes. But my promotional avenue, whether I will be in the lower feeder or I will go up, that has not been considered. In 2018, 16-17, there was no gradation list. In 2018, a gradation list was published with respect to 2016 and 17. There I raised the objection.
And what was your objection?
Objection was that the persons who ought to be below me, they have jumped upon me.
What is the principle for promotion? Seniority cum merit.
Seniority cum merit.
That is the principle to be applied for
Principle to be
promotion.
applied to maintaining gradation list.
No, for the promotion.
For the promotion, my lord.
Seniority cum merit.
My lord.
Therefore, you were overlooked
Lord.
because you did not feature in the. And what about the 25% quota as far as the?
Nothing.
That quota has not been filled up.
Thereafter, my lord, what happened? I filed an RTI application. In the RTI, they replied there ought to have been a 10 number of seats vacant, but they have kept 3 numbers of seats vacant.
So how does this change the position?
Well, I was not allowed to. Even, my lord, in 1914, in the notification dated 1914, there was no whisper about the geo, no whisper about the quota, no whisper about the promotion.
Which means all the in-service candidates were denied promotion.
My lord, actually, we're grateful to your lordship.
By the 19-2014.
My lord, grateful lordship. This is the hunch.
And how has this? এটা কি দরজাটা কি হচ্ছে একটু দেখতে বলো তুমি বসে আছো এখানে একটু দেখে বলো কাউকে and then how is the single bench dealt with it?
That one has not been dealt with.
Yes, Mr. Banerjee.
That something has been pleaded, Millard, something else is argued.
Let us have your microphone.
Millard, what is pleaded is not argued today. Millard, this notification.
And what is argued has not been
pleaded. Absolutely. Absolutely. Millard, my learned friend today is suggesting that, Millard, the notification dated 1st September.
What is a tank is not a land. Yes.
Millard, my learned friend is suggesting today before your lordships that the notification dated 1st September 2014 was bad in law because, Millard, this was not issued, Millard, in tune with, Millard, the recommendations of Shetty Commission. Millard, page 29 is the prayer portion of the writ. If my lords kindly take the trouble to just take note of, Millard, the pages and the dates. Millard, I'll try to be, Millard, as precise.
Take a part of. Take a part of.
Millard, page 236, Millard, is the recruitment notification dated 1st September 2014. Page 236, which is, Millard, which was not under challenge in the writ petition. Page 29, Millard, the prayer portion of the writ petition starts.
Yes.
Millard, that was not under challenge.
Only the gradation list was the challenge.
Millard, the only allegation, Millard,
that was, my lord, agitated, with the grievance, my lord, that was agitated before the Honorable Single Judge was that, my lord, the petitioners have been superseded by 3 named persons in the gradation list of 2016-2017. That was the only allegation. Now, my lord, this 2016-2017 gradation list, my lord, was prepared on the basis of an accepted gradation list of 2014-2015. My lord, a draft gradation list was published, my lord, for 2014-2015. Objections were invited. My lord, my learned friends, clients, my lord, raised objections in writing. My lord, their objections were limited to the extent of, my lord, misspelling of their names. No other objection was raised. They were heard. My lord, their objections, rather, my lord, were considered. My lord, order was passed, which was then, my lord, affirmed by the learned, my lord, sessions judge, my lord, city sessions judge. My lord, the order, my lord, dealing with their objections, not under challenge, was not under challenge. My lord, the approval order or the confirmation order passed by the learned city sessions judge was also not under challenge. My lord, after, my lord, these objections were dealt with, my lord, again a draft, my lord, gradation list was published. Initially proposed gradation list, then draft gradation list. My lord, again objections were raised. The objections which are now being raised, my lord, did not find place there. My lord, again a final order was passed which attained finality after, my lord, a second time approval from the learned sessions judge. My lord, these orders were also not thrown any challenge to in the writ petition. Now, my lord, on the basis of this, my lord, gradation lists of 2014 and 2015, my lord, the gradation list of, my lord, 2016 and 2017 was issued. And my lord, naturally, my lord, they could not have, my lord, taken a second objection, which they did not. My lord, they chose, my lord, not to take. Which is why, my lord, the Honorable Single Judge, my lord, has been pleased to observe that, my lord, the writ petition is hit by the doctrine of waiver, estoppel, acquiescence, and, my lord, the analogous principles. My lord, that has been the observation of the Honorable.
Mr. Shamanto just said that when the objections were invited in respect of the gradation list of 2014-15, only objections with regard to the spellings of the names and some clerical errors were
The
invited.
invitation was not confined to that. My lord, the objection was confined to that.
So any other objection could have been raised.
Had they chosen, my lord, they could have. And, my lord, this objection that, my lord, 3 persons have superseded them, my lord, was taken, my lord, in the second time. That was also considered, orders was passed, which were not under challenge in the writ petition. And then, my lord, the final gradation list was published.
So that takes care, Mr. Banerjee, of the gradation list part.
Yes.
And whatever followed from the writ petition.
Yes.
And decided by the single bench.
Yes.
Now, please come to page 31, prayer C.
Yes, ma'am.
Rule commanding the respondents to fill up the, not to fill up the post for promotion from amongst earmarked in terms of SETI commission. Now, this story of the promotion is brought into this prayer. What is the nexus between the two, if at all, and how has it been maintained? And if not, whether were not maintained, and finally, even if not maintained, they do not have a right.
My lord, the basis of this prayer, my lord, is the allegation that they were not, my lord, taken into the zone of consideration in terms of the notification of 21st September 2014. My lord, here, my lord, they are possibly subject to correction by your lordships. My lord is arguing, my lord, a self-defeating case. My lord, if they say that, my lord, they were entitled to be considered through the promotional avenue.
No, sorry. Court, no, court management ke daku, Alipashta bondho kore, upashta kule.
My lord, my learned friend has argued that, my lord, there are 2 channels of, my lord, recruitment. One is direct recruitment through selection process. One is, my lord, promotional avenue. My lord, if they say because of, my lord, their position in the gradation list, my lord, they were held not to be entitled to be considered for the promotional avenue. My lord, that is some case. That is one case. And the other case can be, they were not held to be entitled to participate in the selection process. So far as participation in the selection process is concerned, two dates and 2 pages are relevant. Page 52 is the date of confirmation of their appointment to the posts of peons. The confirmation took place on 15th November 2014. With, of course, retrospective effect. And the recruitment notification is at page 236, which was issued on 1st September 2014. So, the date when the ball was set in motion, the recruitment process started, they were yet to be confirmed into the post of peons. So, they were held to be not entitled to participate in the selection process in their capacity as peons before their confirmation. But this is on merit. Possibly they waived their right to argue this after having raised objections to the gradation list, after those objections having been considered disallowed, and no challenge being thrown to the orders passed disallowing their objection. My notes of argument, I tried to make it as crisp as possible. The dates are indicated, the page numbers are indicated.
About the 25% promotional quota, as he argues, which by the Shetty Commission must be from the promotees, prospective promotees.
That is a challenge. That could have been a challenge, a point of challenge to the notification. The High Court administration never got an opportunity to respond to that, because that was neither here nor there in the writ petition. There was 1 or 2 paragraphs spent for that, but no prayer in the writ petition to the effect that the notification is bad.
True, but that apart, even if there was no prayer, if there was a statutory or a mandatory guidance on you from the Shetty Commission that 25% should be kept, that 25% should have been kept and carried over, How have you?
But
and
then,
then that even a day would have happened when they would have qualified for
then,
that.
I need to check the recommendations of Shetty Commission, because this was not argued.
Yes.
This was not pleaded as such. 2 paragraphs, of course.
Was it there in the Shetty Commission?
I need to check.
No, but that is beyond the scope of the writ petition.
In my humble submission, yes, but I have a duty to answer any query that falls from your lordships. Then if my lords kindly grant me a day or 2 days time, I will check the Shetty Commission's recommendation, come back and assist your lords.
Because then the only question would be whether
the notification was not in tune with the recommendations of the Shetty Commission.
Of the Shetty Commission. Therefore, as per their present facts, they are not entitled to claim the 25%. Claim against the 25%.
I was just wondering aloud whether this point whether they had the locus to ask this.
Correct.
This is not a public interest litigation. Whether they had the locus to ask this point. This being an adversarial litigation where they are saying that 3 private individuals have superseded them.
That is all.
If my lords want us to make submissions on
then have you promoted from the in-service quota?
I need to take instruction. Those were we are never invited.
Only that part of this.
I will
only that part of this.
I will take instruction and come back. I doubt what is being suggested is correct. Firstly, it can never be seniority come merit. A recruitment process for filling up any post in judiciary. I have never seen the principle of it is merit come seniority. If 2 are of the same merit, then the senior comes first.
But this is promotion, not recruitment.
This is selection through 2 avenues. Promotion not as a matter of right. If my learned friend says seniority come merit, then this is not a matter of right. Becomes a selection process, essentially. I doubt this submission is factually correct.
This is to the Group C cadre.
From peon to lower division assistant, lower division clerk, and process server. In City Sessions Court.
To Group D to C.
Possibly, yes.
D to C.
Possibly.
D to C. So if that is D to C, then It is actually an upliftment of cadre.
Correct. And my lord,
So
their seniority-
you're not inviting outsiders to participate, not open selection,
not open selection.
in-house selection. Then where is the basis for 25%?
My lord, I doubt, my lord, this is correct
It
submission.
is either 100%, whatever is the basis for 25%.
Because my lord, whoever participates, my lord, is an in-house candidate.
Correct.
And there, my lord, the purpose of the selection process would fail if, my lord, the basis, the criteria is seniority cum merit. The process, I mean, the purpose of the I'm sorry.
Just a minute.
I hold a selection test and then, my lord, I select, my lord, the senior most candidates. My lord, then possibly, my lord, the purpose of, my lord, the selection process gets frustrated. We are always, my lord, the judiciary is thriving for, my lord, the best candidates. My lord, Justice Banerjee is hearing a matter where, my lord, again, my lord, this question has arisen whether by expanding the zone of consideration, my lord, High Court is acting in violation of a rule or not. My lord, there also, my lord, our answer has been that we are, my lord, looking for the best available candidate to fill up any post. Well, that should be, my lord, the underlying theory, my lord, for bottom line, my lord, for filling up any vacancy in judiciary.
That will be all, Mr. Banerjee, for
My
the
lord,
now.
accepting, my lord,
That part. Let us
Static
see.
commission.
Why are you really into now? He says there are no pleadings, Mr. Shamanto. As far as you're concerned, the gradation list was
Two
your problem,
paragraphs are there.
and that gradation list
No
problem
prayer.
has
Two paragraphs are there, but no prayer.
therefore.
My lord, I think, my lord, my prayer C will suffice for that, my lord. Prayer C, as your lordship indicated, my lord, will suffice for that. But what my learned friend is.
What are the pleadings?
Lord,
In support of prayer C. What is the paragraph in support of prayer C?
My lord. Page 12.
Paper book page?
1, 2, 12.
Yes.
Lord, I have stated, my lord, the party to mention that Chief Justice Civil Court in 15/14 hold the confirmed services of 18 peons with effect from 1/8/14 in terms of the such and such. Copy was given.
Ready.
Pair 5, my lord. It is significant that in connection with the effect from.
Just a minute.
My lord.
75%.
Sorry.
কি করে?
কি বলছো?
কে সামন্ত? জিজ্ঞেস করো। Yes.
Look. Para 5 is significant to state that in connection with the effect from 1/8/14, the petitioner derived right consideration for promotion after confirmation of the service. Petitioner said the process of recruitment subordinate courts in the form of post of peon, persons such a right of consideration promotion of LDA or the LDC also has a right of consideration for promotion for the post of peon to the post of process server. The petitioner states that on such and such date, due was passed by the secretary in charge, judicial department, implementation of the recommendation of city commission for staff attached to the process serving establishment with notification dated 20th of July 2019. This is the notification what I was beseeching your lordship. In where, my lord, the reservation of 25% has been specifically stated, my lord. Your lordship was asking that whether actually there in the recommendation, city commission recommendation, there was the quota or not, my lord. I have checked up, my lord, that is there, my lord. If your lordship asks me to place that, my lord, I can, on the next occasion, I can show that the recommendation of the city commission clearly says that there will be a reservation of 25%, my lord.
So look at paragraph 11 onwards, page 14. 25% LDC post shall be filled up by way of promotion.
My lord.
That is accepted proposition.
Accepted.
Even possibly Mr. Banerjee will take instructions, accept this. But then now your story begins from paragraph 12. Against 25% you claim to be left out because you were not in the gradation list. So why are we?
I was in the gradation list. I am in the gradation list.
But then you were not confirmed when this recruitment took place.
I was confirmed with effect from 1/8/14. Subject to lots of correction, my lord. The confirmation are made on 15/11/14, but with effect from 1/8/14, and the recruitment started on 1/9/14. But this is, humbly beseeching, this is not my fault that I have not been confirmed on the very day. The notification was not issued on the very day when my confirmation was done.
And if it started on 1/8/14,
my lord,
your position in the gradation list was such that you could not be.
I will be.
You could not
I
be
would,
brought into the
and
zone.
your lordship was asking further that whether the in-service persons have been given promotion or not, my lord. My lord, I have the instructions, my lord. The other persons who have filed the petition or the appeal, in accepting these 5 persons, all other have been given promotion. They are being punished from filing the writ petition. They are being punished only. The past 18 persons who joined.
Those are statements which are from.
No, my lord, I can file an affidavit, your lordship. So
no more affidavits.
No more. The state can apply, your lordship, my lord.
So that's right. They are before this court. We will look into their grievance.
But the 18 persons joined on in the same notification.
So why do you say you were left out of the 2014 recruitment notification promotion?
There was no avenue for myself. There was no avenue because the 25% quota was not there. But the notification says.
But how could your contemporaries or they could be promoted with in the 25% quota?
In the other subsequent notification, they have been considered. Myself has not been considered for filing the writ petition.
Mr. Banerjee, we do not want to make it more complicated than what it is. Their right to claim against the 25%, what if you have done with the, doesn't seem 25% to us. It's 100% group D beyond to group C. Where is the 25%?
Kindly will take page 53, which my learned friend is harping up.
53.
53 Miller read with the notification at page 238, 236. These 2 pages, Miller possibly to be read side by side. Kindly Miller see what was the scope of the notification at page 236.
Yes.
Kindly see the posts which were intended to be filled up. Under this notification, first one at page 236 bottom is stenographer. My learned friend is not concerned about that. Then
let us read the notification.
Yes,
briefly.
may I? Notification for recruitment of different categories of posts of staff in the city sessions division to be conducted by the committee of the judgeship under the supervision of the Chief Judge, City Sessions Court, Calcutta. Applications from the eligible Indian citizens in the following prescribed format are invited for preparation of separate panels to fill up the existing vacancies mentioned below in different categories of posts in the judgeship of Chief Judge, City Sessions Court, Calcutta, etc. The examination or test of a particular category of post will be held in a particular day and time to be notified later on. Details of vacancies, scales of pay, respective application fees mentioned above by IPO need be drawn and the same is payable, etc.
That will be all right. But therefore, this is an open recruitment.
Absolutely. And now, Malad, kindly take page 53.
Now, let us see what you are showing, the posts.
Then, Millard, kindly see the posts. Millard, total vacancies were, Millard, 73 covering everything.
Yes.
First post was, Millard, English stenographer, which Millard, he is not striving for. Then, Millard, lower division clerk.
Yes.
This is, Millard, possibly the post, Millard, which, Millard, they wanted, Millard, to get promoted to.
Yes.
Then, Millard, copyist is not, Millard, the concern of this proceeding. Poddar is not the concern. Process server. Millard, if my learned friend is suggesting that he wanted promotion from group D to group C, even process server goes.
Yes, goes.
Peon, Millard, they are already peons. Farash, Millard, group D. Visti, group D. Sweeper, group D.
So that leaves only LDC.
Millard, subject to my
Correct.
limitation.
Now, what is the 25% quota?
Now, Millard, kindly take page 53. And Millard, this was
lower division clerk.
Correct.
Now, my lord, my learned friend wants to rely upon, my lord, page 53. And the submission is, my lord, this is a notification which was issued, my lord, following the recommendations of City Commission. The post advertised is, my lord, lower division clerk. Kindly take, my lord, the bottom of, my lord, page 53 on the left hand side. First one deals with process server.
Out of it, it is group D. So he's out.
In, my lord, comes belief. My lord,
This is what? 20th July 2009.
correct. My lord, two posts are, my lord, taken into consideration in this notification. One is process server. My lord, if I go by page 37, process server, I find, my lord, it's a group D post. Specific case run by my learned friend today also before your lordship is that, my lord, they want a promotion in group C. They want a berth in, my lord, group C category. And, my lord, the next post under, my lord, the notification at page 53 is belief.
No, kindly come just above bailiff.
Yes, my lord. Reservation to group C.
In group C
My lord,
post.
this is under the heading process server.
No.
A, B, C. Then, my lord, there is, kindly see, my lord, Roman 1 is process server.
Correct.
Then, my lord, under Roman 1, clause ABC.
Correct.
Then, my lord, Roman 2 is belief, and that is all.
No, but what is the meaning of Roman C in Roman 1?
Clause C in Roman 1.
Yes, what is the meaning of it?
Reservation in group C post clerical catering. Process service. Can we see, my lord, the statements, my lord, under, my lord, this heading, reservation in group C? Process servers with requisite qualification shall be considered for promotion along with other categories of group D employees to the extent of 25% in LDC cadre in the ratio of 1:2, process server 1, other group D employees 2. But, my lord, this is possibly, my lord, for belief and summon belief. Possibly not for, my lord, lower division clerk. At least, my lord, my humble reading, my lord, that's my interpretation.
This.
No, they need to clarify this.
AI, my lord.
How, my lord, they apply this, my lord, to their case.
This is applicable to me, my lord. This is applicable to me, my lord.
You are catching on to wherever we are leaving off. We left you at 25%, you caught on to that. We left you at prayer C, you caught on to prayer C. Now we are leaving you at page 53, you have caught on to page 53. What is your original case?
Perhaps, my lord, I started with page 193, my lord. Perhaps, but lordship is absolutely correct, my lord.
Yes. Page.
This notification I was showing in page 137. The same notification has been annexed, my lord. I was
so your group D.
Group D. I want promoted to be LDC. Group C.
Group C. Where is the notification according to you for the promotion?
Same notification is page 137. 137 more legible copy.
137.
137, my lord.
137.
Yes, my lord. 137 is the forwarding letter, and 138 is the notification. And the relevant party is at 139 top.
So the process server cannot be a group D post then. It has to be a group C post.
There is some ambiguity.
It has been written process server. Reservation in group C.
So the 8 keywords.
But with this,
so what is the meaning of yes?
আর প্রসেস সার্ভার থেকে 1 আর আদার এমপ্লয়িজ থেকে 2 in group clerical cadre প্রসেস সার্ভার থেকে একটা নেবে আর গ্রুপ ডি থেকে দুটো নেবে দিস ইজ দ্য রেশিও করে ওরা ডিভিশন ক্লার্ক নেবে গ্রুপ সি পোস্ট
এখানে এদের ঢোকানোর কি মানে হলো?
প্রসেস সার্ভার থেকেও নেবে, আদার গ্রুপ ডি থেকেও নেবে, কিন্তু প্রসেস সার্ভারটা হলো গ্রুপ ডি। আর এখানে এটা ক্লিয়ার যে প্রসেস সার্ভারটা গ্রুপ ডি, এখান থেকে ওরা নেবে, আর আদার গ্রুপ
তো সেটা এই রিক্রুটমেন্ট যেটা বেলিফ আর প্রসেস সার্ভার, এর মধ্যে ঢোকানোর কি মানে হলো দেখে নিচ্ছি।
প্রসেস সার্ভার and also group C clerical cash.
Yes.
Process server qualification that
May I, my lord, suggest one thing? And my lords need not take the pain, my lord, to, my lord, I will just, my lord, take instruction, come back any day that is convenient, your lordships. My lord, pattern point on this.
process server একটা করে নেবে, আর এই এতগুলো বেসিক থেকে বেসিসটা দেশীয় করে গ্রুপ সি ক্লাবটাকে ফিল করবে। এটাকে এত কমপ্লিকেট, একটা করে প্রসেস সার্ভার, দুটো করে বাকি পোস্ট, বাকি পোস্টে দুটো করে, এতগুলো পোস্ট থেকে দুটো করে নেবে।
Very well.
But my lord, this was neither here nor there in the writ petition, in the argument before the honorable single judge. He's expanding the scope, my lord, of the writ petition. I will answer to.
Those were there, my lord.
Yes.
But those were there. What my argument says, my lord, those pleadings were there, my lord, but in a limited pleadings were there, but pleadings were there, my lord.
So you came to the prayer with a prayer for came to the court with a prayer for correcting the gradation list, primarily.
Secondarily. Primarily, my issue was for non-consideration of the GO.
Of?
The GO.
2014.
No, my lord, this GO, what is lordship is looking at, 20th July 2009, with in compliance with the city commission recommendation. That was the primary one.
My learned friend gets wiser today.
It's like he has to beat Neeraj Chopra in throwing the javelin. We'll try. We'll see we can. You come when can you come back? Next Thursday?
After 26th, 27th and 28th, I am not there. Accepting these 3 days, if it at all possible for your lordships.
4th May. 4th May.
Yes.
So get the what we just want to know. Our gradation list story is fairly now open for us. We want to know, so this promotional bit, how much did they want to squeeze in that in the promotion? And then have they impeded those persons who are party who have been promoted? If that is the story, you have not done that.
No.
But honorable single judge did not go into that also, because they had waived their right. Yes. Even if today, my lords are inclined, to.
No, not for nothing. Honorable single bench may not have correctly appreciated the whole issue. That is why this appeal. Because he did not go into it, that does not mean the point doesn't
Placed,
stand.
cannot be appreciated. Something not placed, cannot
That's
be
right.
appreciated.
That's it. That is. The honorable single bench would not be the honorable single bench went into the issues. It appreciated. But if there are issues are still somewhere embedded in the writ petition, then he can take it up in the appeal. We can.
If anybody wants to delve into the merits of the case, look into notification and all that, whether they were superseded or not, then those 3 persons become necessary parties.
That's right. That's right. That point is also not lost as far as you are concerned. So we come back on that aspect only. Right. This party this slash party this slash are represented in the order of their names printed above. So para by the previous order of this court dated the 16th of March 2023. The matter was placed for clarificatory arguments. Para parties place their respective arguments today and pray before this court to submit further arguments. I pray for this court for an opportunity to submit further arguments. On the next day, Subrata, accordingly, let the matter appear. Next, under the same heading, fixed matters. Fixed matter, acta matter, at 2 p.m. on the 4th of May, 2023. Fixed matter, 2 p.m., 4th of May, 2020.
Great. Yes.
This is the
Contempt, my lord.
what we are waiting for, actually. Mr. Kumar versus Mr. Ghosh.
Lordship, SLP.
Who you have filed the contempt?
Yes, my lord.
I am
You have to be this side.
Yes, my lord.
Mr. Kumar, you are for the alleged contempt.
respondent. Copy not, sir, but
Let us
Lordship, SLP is pending. The diary number is 33.
देखिए file था देखिए किताब।
608.
My lord, item number 2 and 3 were hard.
3 was implemented.
Well, may I? Well, both the matters were had together in September. In August, thereafter, judgment was delivered, my lord. And my lord, on the same day, mat number is only one is different. And my lord, item number 3, they preferred SLP that has already been dismissed, my lord.
Which is the contempt application?
My lord,
You have brought a
both the matters, my lord, 2 and 3, arising out of the same order, my lord.
3 implemented. But because 3 was dismissed, 2 was pending.
there are two contempt applications.
My lord, of different person.
That's what is the which is the contempt application in respect to item number 2?
2 is, my lord, the
SLP is pending before Supreme
well,
Court.
I am coming to that, my lord. If you just kindly see your lordship's order, my lord, page 27, my lord.
What is the number of the contempt application?
My lord, 1010.
In item number 2.
My lord, item number 2.
Very well. We'll look at our order in item number 2 and
My lord.
approach each of the contempts separately.
My lord, yes, I have separate.
Yes. ECL.
Yes.
No, that has not been implemented, my lord.
Yes, Mr. Kumar.
SLP file SLP is pending.
Which is the next date?
Next day never fixed. Even in Lordship's court matter never fixed. I passed number of matter before your Lordship. December never called. Problem is this everywhere. This is the problem.
We'll handle each problem separately. So what is the diary number of your SLP?
Diary number is 33608.
Very well. We'll give you one more chance. If nothing happens, we will you take up.
Lordship, one matter, Lordship passed the single bench order, payment of order, Supreme Court stay the order.
Maybe. So
then what? Lordship, the single bench, Lordship, before your Lordship pending, single bench asked to deposit. Supreme Court.
Different matter, my lord.
Matter.
Mr. Kumar,
Lordship.
don't let us approach the issue in a logical manner.
No,
You have filed a contempt. You have filed an SLP against our order.
Matter is pending. SLP.
Correct. We will give you time. Come back with subsequent developments. If not, we will take our steps. That is all that we are saying.
Because I see the problem. The one matter is stay, but here Lordship.
Whatever it is, we will.
How
much of time do you want to come back with a subsequent development from the Supreme Court?
2-3 months.
We will not, you will get a month. You will get today we are on the 20th, we will meet immediately in the first week of May. And then if you...
No, not May, no, impossible.
You will not be...
Lordship, Supreme Court saying you are dictating me. This is the statement of the Supreme Court judges.
That is yours.
Supreme Court says that you are I will call a serially.
Ashun.
My lord, may I submit one thing? My lord, this is a very, only 1 minute kindly, my lord, give me, my lord. My lord, in October, my lord, I have filed in the morning. Kindly see in October, they have filed this SLP. Even diary number, my landed friend is saying wrong. I have given the correct copy.
This is the message come.
Now kindly see the caption, my lord, in bold. Kindly see the date of filing and capsule. After 90 days, they defective, they did not, my lord, cure the defects. Not refiled after curing the defect, after 90 days.
Supreme Court will go in for summer vacation, and after it assembles, I will retire. So the question is, I have a duty from my conscience to deal with this contempt application so long as I am here. So therefore, we are fixing a date after a month. Come back, mention the matter there. Yes. And if it is whatever it is,
not filed. My lord, in the eye of law, there is no SLP. Kindly see.
Another matter, Lordship, this court directed payment, there stays out of the division bench. Another matter, this is the problem.
There is no SLP in the eye of law. No diary number. They have not chooses to not to file anything, my lord. Kindly see.
Have you refiled?
No,
Have you refiled?
But this is today's printout. I have to.
Have you refiled this appeal?
we have an extra copy of that.
2 copies I have given, my lord.
Why don't you bring a third copy? You could show my learned friend.
Sorry,
that is always the problem with learned juniors who do not prepare, who prepare just exact number of copies.
Yes, but I have, my lord.
Not
because
refiled.
today's printout shows that there is no SLP in the eye of law. Mr. Kumar, please try to appreciate. Because it was defective in October and you have not refiled within 90 days.
I have no idea about
so within 3 months, you have not refiled it. So there is no SLP in the eye of law.
I have no idea about this.
You have no idea.
No.
You are submitting that there is an SLP.
SLP, Lordship, they sent me what is today, just now I am saying. Refiling system is not system. Refiling, again refiling that they remove the whatever they remove.
Well, in this matter, kindly issue the rule, give them time, and my lord, let it come, my lord, after 1 month.
Not 1 month, within 2 weeks. If the defect is not cured, then we will look into it. Then the question of month will happen.
I am praying for, my lord, to issuance of rule, my lord, subject to your lordship, my lord.
Hmm. Yes, Ashok.
Lordship asked to serve one copy to me. They have not served any copy.
Copy of the contempt application. You want a copy, you take a, if you want a copy, take a copy, but come back with a
My learned friend supply me copy, will not supply. The basis of list I appeared.
At 20th, 4th May to amra boshchi. This will be a parties slash are represented in the order order of their names is printed. Any other defense you have, Mr. Kumar?
No, nothing.
Very well. Party this slash are represented in the order of their names as printed above in the cost title. Full stop. This is a contempt application. Para brought out by the applicant slash the applicant, comma, who was the respondent slash writ petitioner before this court in the appeal. Full stop. In the contempt application, comma, being CPA 1010 of 2022, comma, the applicant alleges non-compliance of the judgment and order of this court dated the 2nd of September 2022 within bracket Supra, bracket close, on behalf of the alleged contemners, comma, Mr. Kumar, comma, learned counsel appears and purports to produce before this court details of a special leave petition filed before the Honorable Apex Court, full stop. However, comma, from the documents produced by the applicant before this court today, comma, which is not disputed by learned counsel for the alleged contemners, comma, it is discovered that the purported special leave petition has been classified as a defective matter, a line to her. Bold defective pencil, defective matter, not refiled after 90 days. Full stop para. This court is informed that the purported special leave petition was filed on the 18th of October 2022, and hence the period of 90 days for refiling of the same stands long exhausted. Full stop. Para. It is no document, no material is produced before this court. No particulars, no particulars are also produced before this court that the SLP, that the defect has been removed and the special leave petition has been refiled at the end of the period of 90 days. Full stop para. In the above factual scenario, comma, full stop para, in the above factual scenario, this court at this stage must observe that there is no special leave petition subsisting in the eye of law. Full stop para. Learned counsel for the alleged contemners seeks time to bring appropriate instructions on the next date. Full stop para. Accordingly, comma, let the matter be placed for consideration next. Duto alada kore diyo. Dui ya tinta alada kore diyo. Next.
3 is implemented.
3 we have not come so far. Consideration next on the under the same heading, contempt applications on the 4th of May 2022-23 at 2 p.m. 2 p.m. bola dorkar nahi, 4th of May.
I record that I will sub copy. Otherwise, again, unless you will also direct.
You a copy. Let a copy of the contempt application.
The name
Let a copy of the contempt application be served by the
Mr. Kumar.
applicant on learned counsel for the alleged con- on Mr. Kumar.
Or Mr. Kumar.
Mr. Kumar is a very age-old practitioner.
Yes, ma'am.
I think Mr. Kumar's father was also a practitioner.
My father is senior to SBC now, Justice.
Yes. He has a legacy of.
Yes, my lord.
So I'm sure on the next date he will bring correct instructions.
My lord.
I am also Mr. Sorin
Yeah.
Sorinda.
Yes, again. Item 3.
Implemented lordship, I file compliance report, implemented payment made.
So, dismissal of the copy of the
What we directed to do.
Compliance report I will file next day. Already payment made, lordship. Because SLP dismissed.
Similar order, my lord. Item number 2.
But this is already payment made. What is similar?
No, I am not saying that payment has not been made. Since they are want to file, my lord, the compliance report, let they file. I have received payment. I will not say anything, my lord, that I have not received, they have not implemented.
By 4th of May.
Compliance report, lordship.
Yes, by 4th of May.
100.
It is submitted, parties reported. It is submitted by Mr. Kumar, learned counsel appearing on behalf of the alleged contemners, that the judgment and order dated September 2, 2022, passed by this bench, has been complied with, full stop. He prays for leave to file a compliance report, an affidavit of compliance on the adjourned date of hearing.
Also, my lord, can I record my submission that payment has been made? Otherwise, he may say that I have not said.
Mr. Ghosh, learned counsel appearing on behalf of the applicants, submits that payments have been made in terms of the judgment dated September 2, 2022. Full stop. Next. Let the matter appear for consideration under the same heading. Contempt application for the heading. Contempt application to bold on May 4, 2023. What are bold? Server copy. That server copy again. An SLP and a special petition was referred from the appeal being MAT number 1007 of 2022. Full stop. The same was dismissed by the Honorable Supreme Court by an order dated January 3, 2023. Full stop. SLP order. পাঠাটা এই একই ব্যাপারে এমএমসিসির ব্যাপারে from the date ওরা ফাইল করেছে ECL.
Yes.
Your voice has improved. Should we call your matter or not call your matter?
3:30.
There are 2 matters made part hard. Another matter is not in the list, one matter is in the list. Similar order will be passed. Part hard matter.
We'll see. Give the slip.
Well, I'll
give the slip.
My matter also part hard, lordship, before lordship.
I am saying his matter, my lord.
His matter, his matter.
Enough.
Two matter.
Two matters.
Two matters.
Two matters. Give the slips to, if it is parted, we'll put it in the list,
Parted,
we'll
my lord.
see we'll see where we
Same issue.
After half an hour, I will.
Kiti?